Yes.
Lordship, you make a mention.
Well, beg to make a mention for listing of mention for orders. I had given the date before the race, made an entry with the registry, but that has not materialized. It was done on 16/10.
Please approach them again.
Well.
All right. Please approach the registry.
I done on 16, a
know,
number of
but-
cases have been put on note, but then they're not coming. It's not
No,
working
you
somehow.
take it up with them again. I'll also put a word. Okay.
Lordship, as regards item number 9, it has come up for orders. There's a direction to the respondent number 1 to file response, failing which he was directed to appear personally before the zonal court. Lordship, we have recently been engaged, your Lordship, as the BTC council, your Lordship. As a council for BTC, as well as a council for respondent number 1 also. Although, Lordship, we have received a instruction, my lord. Lordship, we'll put it on record. Lordship, short accommodation be given, my lord. I have taken the concern on the other side.
That's it.
Item number 9, my lord.
Ms. B. Bhuyan, Lanet Senior Counsel, submits that she has been recently engaged by the respondents and therefore, respondent number 1, and therefore prays that she may be given a week's time to file a response considering the prayer and the same not being objected to by the other side. Let the matter be listed again after a week.
Or shall date be fixed?
You want a date?
Like if
That's
it then I'll-
No, after a week on a date to be fixed by the registry.
Lordship, as regards item number 14, I have taken the concern of the other side. We have no records available with us. I've taken the concern of the petitioner. Only he say, Lordship, he has said Lordship to take a fixed date, my lord. Counsel for the
Ms. B.
petitioner.
Bhuyan, Lanet Senior Counsel, submits that she will be representing the BTC respondents and she needs 2 weeks' time to organize her brief. As paid for and not objected to by the other side, list the matter also and so. 1811.
Deeply obliged, my lord.
May I please, the Lordship, my lord? Lordship, with the consent from other side, I beg to mention item number 12, Lordship. The matter may be adjourned for 1 week, Lordship.
Why? Why do you want adjournment?
My senior has some personal difficulty, Lordship.
Who's your senior?
Mr. NNB Chaudhary,
Okay, and who's for the other side?
I'm for the board.
Portland University,
Well,
Lordship.
if possible, my date may be fixed, 19 matter.
There's some urgency.
There's no urgency, matter is 19. If
Okay.
possible, if
Mr. NNB Chaudhary, Lanet Counsel for the petitioner, is said to have some personal difficulty to appear before the court today. And on a prayer made on his behalf and not objected to by the other side, let the matter be listed for hearing on so and so. Give a date after 3 weeks. 25
I'll
days.
oblige, Lordship.
Much obliged.
Sure, we also appear for BTC in this matter. We also don't have the brief, my lord. I'll take a copy from.
Do that.
Okay.
My lord, I beg to mention item number 5, my lord. Here, my lord, in this case, my lord, the respondent number 6 has filed their affidavit in opposition, my lord. I want to file reply, my lord. So 2 weeks will be granted, my lord.
As paid for 2 weeks' time is granted to the petitioner to file rejoinder application.
I am appearing for respondent 1 to 5.
Mr. SCKR, Learned Counsel, appears for respondent numbers 1 to 5. And Mr. S. Thakur appears for respondent number 6.
Your lordship may fix a date, your lordship, after 2 weeks.
List again on so and so. 20 days.
Well, I beg to mention a matter for listing on Monday, my lord. It was filed on Monday this month.
Motion.
27th.
Motion.
Motion.
What is the urgency?
Urgency is that, my lord, my HSLC examination center has been cancelled. And it has been transferred to a school where there was earlier allegation of malpractice, my lord. So, my lord, earlier that school was attached with the petitioner school as a feeder school.
All right.
All right.
May I please your lordship, with the consent of the other party, the item number listed 13 may be adjourned for a day since the engaged counsel is out of station.
13.
Yes.
Sukhbir Raman.
Sorry, lordship.
Petitioner's name is,
Item number listed is
what is the petitioner's name?
Sakibur Rahman.
Okay. And who's you're mentioning on behalf of the petitioner?
Yes, sir.
Who's out of station?
The other party, counsel, senior counsel,
Who's that senior counsel? Who's absent? Who's out of station?
R is one. my lordship.
But Mr. Chaudhary is also there.
Oh, Mr. Chaudhary.
Who's out of station?
Mr. Chaudhary.
Have you informed the other side?
Yes, my lordship.
Okay. Mention has been made on behalf of Mr. M. Chaudhary, the lead counsel for the petitioner, to the effect that since he's out of station, the matter may be adjourned for 2 weeks.
A day.
Stop. The learned counsel mentioning the matter. Miss, your good name?
J. Ashraf.
J.
Ashraf. Ashraf.
Ashraf. What's the spelling?
J.ASHRAF.
You got it? Submits that she has taken the consent of the other side as well. In view of above, matter stands adjourned for 2 weeks.
Thank you, Taj.
Matters for orders, item 7.
May it please your lordship. My lord, your lordship, may kindly see the last order, my lord. The respondent number 5 was asked to, my lord, take instruction. It's matter.
Well, in this matter, my lord, I'm appearing for the headmistress and the school managing committee, my lord. My instructions are awaited, but my lord, oral instructions are this. The amount, my lord, was diverted from that MDM scheme. And my lord, it was used for the school purpose only, for the construction of the building. Well, there's no dispute on that, but the amount was not misappropriated. The only difficult part is this, my lord. No approval was obtained before, my lord, diverting the fund. Seven.
My lord,
Mr. Adhikari,
Affidavit.
you are appearing for
For headmistress,
respondent number?
5 and 6.
5 and 6, my lord. Yes. The headmistress.
So you file your affidavit then?
Yes, yes.
When will you file?
No, 10 days time will be good.
Yes, sir.
Okay.
Regarding
wait for-
gratuity, your lordship, gratuity, my lord. If there is no DP, my lord, regarding this misappropriation amount, that gratuity, how does can be withheld, my lord?
It
Gratuity.
will be, yes.
Anyway, let whatever your readings you have to file, you file, we'll see. As paid for by Mr. M.R. Adhikari, learned counsel appearing for respondent numbers 5 and 6.
I will also.
10 days time is granted for filing affidavit of opposition. Stop. Similarly, Ms. P. Das, learned standing counsel,
P and 4.
education appearing for respondent numbers 1, 3, and 4 is given similar opportunity to file affidavit in opposition. Mr.
M. Sharma.
M. Sharma, learned counsel appears for the petition. List again after 2 weeks
Date may be fixed. Date may be
on so and so.
highly obliged.
Item 8.
And this matter may be taken up after some time, my lord. B. Kosik is on legs, my lord.
Okay. Timing.
Put one of the practice.
Item 10.
May I please? Supposed to give the and Namas is there.
Which is the order not complied with?
Page 34, my lord. Paragraph 28.
Please read.
Page 34,
Read.
paragraph 28. Page 34.
Read.
Accordingly, the impugned order dated 16/7/2024 stands set aside and quashed. The matter stands remanded to the respondent number 2, that is Director of Secondary Education Assam, to pass an appropriate order allowing the petitioner herein to hold the charge of the headmaster of such and such school. As of now, my lord, they have not complied with me.
This order was passed on which date?
My lord,
27/2.
yes, sir.
There's no time frame, isn't it?
There is no time frame, but they have preferred one appeal, my lord. In that appeal was reached before the division bench one day, and it was opinion of the honorable division bench was in our favor. Though order was not passed due to the bench arrangement, my lord, but the opinion expressed by the honorable division bench in the upholding the judgment of the single.
Where's the judgment?
That is order is not passed, my lord. It is pending. Yeah,
Then?
only expression is made verbally.
Oh, expression is enough.
In presence of my learned friend
No,
Khatania.
I was not there.
Khatania, sir. And and they have also passed one similar contempt in case of that case also appeal is there, but they have passed my lord conditional order. The order allowing the petitioner of that case is to hold the charge and the subject to outcome of the writ appeal.
Mr. Kaushik,
I have no instruction, my lord. Lordship will give me 2 weeks time to.
what is the appeal number?
Appeal number, my lord, I'm giving. WA 293 of 2025, my lord.
When was it heard?
Lordship,
When was the hearing conducted?
hearing, my lord. It was last listed on 22/9/2025.
In a party number.
So on that day, some expression was made in
Yeah.
your favor
Yes.
and you're
But
happy
as-
about it.
As the
But it is
honorable,
not sufficient.
as the honorable,
Within the deliberation between the courts, my lord.
Hmm.
yes, but the honorable court was, my lord, honorable justice Eddie Dev Chaudhary was there, my lord, therefore the court was not,
Anyway, Mr. Prakashta, you know very well,
yes, Lordship.
unless it is put down in
Yes, yeah,
writing,
unless it is recorded.
then there is no point.
Yes, but the
In fact,
compliance order I have just given, my lord, that is in respect of the similar.
Another
types-
case.
Yes, that is, they have given compliance, my lord, conditional, subject to outcome of the writ appeal.
No.
Yes,
But that is, Malad, there was an instruction to file a appeal. Appeal is not filed. So this order, Malad, complying till the proposed appeal,
Okay.
the outcome of the proposed appeal.
So you
that's
tell
a-
me,
That's a different thing, Malad.
so you tell me what is to be done.
Here, there is already an appeal filed.
So tell me what is to be done as of today. We'll wait for some time.
Till the outcome of the writ
as
appeal.
there is no stay order in the appeal as on date, my lord.
Hmm.
In fact,
Bec-
Malad, there is no time frame in the order.
They have preferred appeal, my lord,
Mr. Kaushik, if there's no time frame, that means immediately.
yes,
Malad.
after 1 month. If there is no time frame, my lord, as per.
You may like to interpret
Presumably,
it,
Malad.
you may like to interpret otherwise, but as per the court's opinion,
Yes,
if there's no time frame, you have to implement immediately.
immediately,
Presumably.
yes.
But
Yes,
anyway,
otherwise,
this
other-
order has been put to challenge with the Honorable Division.
Unless and until there is no.
when
stay-
is it coming up again?
That is, my lord, last order was given, my lord, to place the matter before the Honorable Chief Justice for constituting a bench, because,
I understand.
yes.
Only that
is-
much.
And that much, yes. Therefore, that on that day, Honorable Court was not able to take the matter.
All right.
Let it be adjourned for 3 weeks, Malad. In the meantime,
No, my lord.
Hmm.
Let them try for listing the appeal, my lord, as early as possible in the first week of November, my lord. And
but
it will
there's
be,
already an order, Malad, by the bench, Malad, for constituting a bench. Malad.
it is their duty to pursue the matter. my lord.
Okay, please write. Mr. B. Prakashta, learned counsel for the petitioner. And Mr. B. Kaushik, learned counsel for the
Response
is-
number 1.
respondent number 1 are present. To stop, allegation made is non-compliance of the judgment and order dated 27/2/2025 passed by this court in WPC number 3929 of 2024.
But-
Stop. Mr. B. Kaushik, learned counsel submits that against the said judgment and order, the state has preferred an appeal, which is registered as writ appeal number 293 of 2025. To stop. It is submitted at the bar due to unavailability of the appropriate bench, the matter could not be taken up. To stop, Mr. B. Kaushik, learned counsel submits that considering the pending appeal, the case may be posted after 3 weeks. Stop, Mr. B. Prakashta, learned counsel, on the other hand, submits that in a case of similar nature, the order of the court was complied with, subject to the outcome of the appeal.
Proposed appeal. Proposed appeal to be filed. There, no appeal was filed, my lord.
Proposed to be filed. Stop. He therefore submits that a similar order can be passed by the respondents as well. Next para, considering the above submissions, this court is of the view that the matter should be posted after 3 weeks. And the respondents should ensure that the appeal is listed for consideration at an early date. List the matter again also, give a date. You take necessary steps, Mr.
My-
Kaushik,
my
and
lord.
do what you can. Otherwise, we'll have to.
We'll apprise this honorable court.
This order may be kept as part of record, Mal.
It'll be here. I need not mention it. Let it be in the file.
Congratulations.
Great from it.
Please, Your Honor. Your Honor, on this, on the last date, I was directed to serve the opposite side the contempt of by Dusty and file my affidavit of service. So that has been done. And there is also further development that I would like to bring to Your Honor's notice. So there were two acts of contempt that we were complaining of. One was that a show cause notice was issued, which was in breach of a no coercive order.
Just a minute.
Please, Your Honor.
Have you filed affidavit?
Yes, Your Honor, that's been filed.
When did you,
It was
Sir?
filed,
no, when did you serve the
the
notice?
service was done on the 6th of this month, Your Honor. And the affidavit was filed, I think, on the 24th. 24th. Affidavit was filed on the 24th, service on the 6th.
Mm. Today is 20, 30. We'll give one more date.
Very well.
All
Your
right.
Honor. Let them respond.
The learned counsel for the petitioner, by referring to the affidavit filed by the petitioner on 27/10/2025, submits that notice has been served upon the sole respondent by way of Dusty as permitted by this court on 6/10/2025. Stop accordingly, notice is accepted to be complete upon the said respondent, upon the respondent. Stop, since no one represents the respondent today. One more opportunity is granted for appearance. And to respond to the contempt petition. List the matter again on so and so. Thank
Your
you.
Honor, may note, I have to submit that one of the contempts have been purged. With plain of one of the contempt, the two issues of contempt that I've raised, one of them has been purged. So they have actually paid the money that I was, that they had withheld.
Learned counsel for the petitioner submits that allegation is with regard to two contempts committed by the respondent, but one of the one has already been purged
Regarding the non-payment of salaries.
in respect of non-payment of salary. List accordingly.
Deeply obliged.
Time being 8.
May it please, Your Lordship. It's a review by the state, Miller.
Okay.
In fact, Your Lordship heard it before. Lordship wanted to see the original records also.
But you'll have to
My lord,
Begin again.
I'll refresh the
I
memo.
have forgotten everything.
Yes, my lord. It's a long back. So we are seeking review of the order at page 59. Orders at page 59. The
Right.
contents of the order starts from page 60.
Yes.
And I'll read from paragraph 2, my lord.
Hmm.
The petitioner claims to have been appointed as an assistant teacher in the Jungle Block High School in Nagaon district as per resolution number 3 of the managing committee dated 30/11/1997. While the claim of the teachers of the Jungle Block High School was considered for provincialization under the Assam Venture Educational Provincialization Act of 2011, one Abdul Khalik, who was a science graduate teacher of zoology, geography, and mathematics, was provincialized as a first assistant teacher. The petitioner claims that she had a legal right to have been provincialized under the Act of 2011 as an assistant teacher in the science of the school. The response number 7, Ahmed Ali Talukdar instituted WPC number 5330 of 2012, claiming his right to be provincialized as a second assistant teacher in the said petition. There was an interim order dated 15/11/2012 restraining the provincialization of the second assistant teacher. During the pendency of 533/2012, the response number 4, being the Director of Secondary Education, by order dated 22/09/2014, had provincialized the service of all other teaching and non-teaching staff of the Jungle Block High School by keeping the second post of the assistant teacher science vacant for provincialization. WPC
No,
5.
just a minute.
My lord.
What was the claim here for the petitioner in respect of?
My lord,
Where
in-
does he figure?
she claims that she was the second science teacher appointed in the school, my lord.
Science teacher.
Science teacher. According to her,
And respondent number 7 is
respondent number 7
also
is
science.
he is also science. Now, what happened, my lord?
So things were going in favor of the petitioner, wherein the respondent number 7 filed writ petition.
Writ petition, and claiming that the respondent number 7 has the royal combination subject, and therefore he should be considered to be as a science teacher.
Interim order was there. Then due to
Interim
the
order was
pendency-
there not to provincialize the science teacher, and therefore there were two teachers to be provincialized, and 2 posts were kept as vacant.
Hmm.
Subsequently, in 5/3/2012, was
Yes.
disposed with a direction to the district scrutiny committee to examine the claim of the respondent number 7, that is Ahmed Ali Talukdar, who according to the petitioner is the first science teacher, and the claim of the petitioner
Okay,
and-
Mr. Kaushal,
and other science teacher.
the writ petition was disposed of ultimately, saying that consider,
Consider.
and the present contempt petitioner, I mean review petition, no, the respondent number, no,
No,
the,
that 5/3/2012 was instituted by the respondent number 7 of this instant writ petition.
Marjan Begum, who's Marjan Begum?
Marzan Begum is the petitioner of the present respondent.
So she was selected.
No. What happened, my lord? During the provincialization process, the one Ahmed Ali Talukdar, he filed a writ petition challenging the provincialization of 2 science teachers. He claimed that he should be provincialized, and there was an interim order operating, and the school got provincialized. The post of science is
So ultimately disposed, the writ petition was
that writ
disposed.
petition was disposed, directing the district scrutiny committee to examine the claims of the petitioner and the other teachers, and thereafter,
Marjan Begum was selected.
what happened, my lord? Thereafter, this Marjan Begum filed this writ petition,
saying that district scrutiny committee recommended her name, but
that's
nothing happened.
correct.
And on that context, this honorable court has directed to provincialize her to
So that's what paragraph four,
conclude the
that is what paragraph 4 says.
paragraph 4 says.
Final consideration direction to the committee
Yes,
to examine the claim. And upon such examination, conclusion, writ petitioner, Marjan Begum is senior and therefore would be entitled for provincialization.
yes,
Since nothing was done, the writ petition was filed.
yes.
And the writ petition was disposed of, saying that
Saying that
Provincialize.
the director of secondary to bring the recommendation of DLC made in
to a
favor of
logical
the petition-
conclusion,
Mala,
to a logical conclusion.
to a logical conclusion by passing an appropriate order. Here, Mala, there are twofold of the order.
Okay.
One is this, and the second part is, as it is a case of deemed provincialization under section 4(1), in the event the authorities are of the view that the petitioner satisfies all requirement of section 3 of the Act of 2011, which in fact would be as because DLC had examined the matter and recommended in favor of the benefits of the provincialization be made applicable from 1/1/2013 as provided under the Act of 2013. Now, my lord, the writ petitioner
So one is to bring it to a logical conclusion. And
the-
secondly is to
give
that
her a benefit of deemed provincialization
deemed
under the,
what is this deemed
my
provincialization?
lord, under section 4. My lord, the effect after the eligibility as per section 3 is
Hmm.
fulfilled,
Hmm,
then the employees under the venture educational institution
hmm.
are deemed to be a provincialized from the date when the act came into force
In a venture school.
in a venture school. That section 4 says.
What is this act?
Act of 2011, my lord, Assam Provincialization of Services
What is the
Act,
full name? The full
Assam
title?
Venture Educational Institution Provincialization of Services Act 2011.
Is there any provision in the Act of 2011
Well,
saying
this,
that
this
deemed?
act has already been struck down.
No,
Ah.
struck down is a different thing. Was there any provision which says that there'll be a deemed provincialization
Yes, section 4. Section 4.
on from the date
From the
the act
date-
becomes effective?
That the date the act came into force, on
Okay.
1/1/2013.
So that is the two parts.
Two parts.
Two parts of the order. One
Now,
is to give a final consideration or to bring a logical conclusion. Second is give that deemed
Benefit of deemed
provincialization
provincialization.
with effect from this date.
This day.
So that was the conclusion. And of course, the Act of 2011 has been struck down.
Struck.
So
So-
today you filed this review petition.
My lord, on two grounds, my lord.
Now, before that, this was passed sometime in 2021
21.
and review was filed in 24.
My lord.
How do you bridge the gap?
My lord, if your lordship will kindly see, when it was examined, my lord, that it is found that the writ petition,
Hmm.
the writ petitioner contended that there was a recommendation by the district scrutiny committee in her favor.
Hmm.
Now, this contention has been based on page 52. Page 52.
No, is that an explanation for the delay?
My lord, there is an apparent error on the face of the record, my lord.
No, that is
Yes,
on merit.
my lord.
Not on the technical part.
My lord.
Why do you come in for review after 4 years?
Delay part I have explained, my lord.
Where have you explained?
My lord, from paragraph 10 onwards.
Let us see.
Page 7.
Please read.
Well, the order dated 28/10/2021 passed by this honorable court in WPC was received by the office of the review petitioner on 1/11/2021 and on 16/11/2021. A detailed report from the inspector of school, Nagaon, in connection with the respondent was called for. The inspector of school, Nagaon, submitted its report on 19/11/2021, mentioning that the district scrutiny committee have recommended the name of the respondent for provincialization as assistant teacher in Jungle Block High School, and thereafter, the review petitioner, after pursuing the records on 16/5 to 6/5/2022, directed to collect the inspector of school's report dated 23/07/2020 and 1/8/2022. Requested the Board of Secondary Education Assam to submit information regarding the number of students appeared in the HSLC examination in the year 2014, 15, 16 from Jungle Block High School, and also additionally requested the Executive Director SSA to submit the UDICE report of the teaching staff of Jungle Rise Block High School for the year 2014 to 16. That while awaiting the reports from the aforementioned authorities, the review petitioner on 31/10/2022 was served with a notice in the contempt case filed by the respondent. After receipt on notice, the review petitioner on 15/11/2022 decided to take an opinion from the Senior Standing Council of the Department of School Education in the present case as to whether the benefit of provincialization can be granted to the respondent with effect from 1/1/2013, now as per Act of 2011. And accordingly, by its later dated 28/11/2022, requested the Senior Council to extend its opinion. The legal opinion was received by the review petitioner on 16/10/2023, and the same was forwarded to the government on 13/10/2023 for issuing necessary instruction. As the Honorable Court, by its order dated 28/10/2023, passed in WBC number so and so to pass speaking order, and thus in compliance, the review petitioner passed the speaking order dated 23/11/2023 in compliance to the Honorable Court's direction. But thereafter, the government instructed the review petitioner to approach the Honorable Court by filing appropriate application and review petition by its later dated 12/2/2024, and asked the Senior Council to prefer a review or appeal as they may be available under law against the order dated 28/10/2023, passed in WPC number 462/2020. Thereafter, the council took some time in obtaining the copies and the record pertaining the draft and finalization of the review petition. Amidst there is no deliberate and intentional delay and laches on the part of the petitioner in preferring the review petition, and the delay which has occurred in the decision-making process, which is unavoidable and beyond the review petitioner's control. The review petition does pray before this Honorable Court for condoning the delay and hear the petition on merit.
What happened to the contempt petition?
Well, contempt petition pending.
It's still pending.
Lord, what happened, my lord, there?
Is there any interim order in the review? Any interim order?
No, there's no. In fact, my lord, with regard to the first fold of the order, my lord, that by passing an appropriate order.
The speaking order has been passed?
Yes, the speaking order was passed.
Where?
My lord,
Is it
it
here?
was passed. The speaking order was passed. (23/11/2023).
There's somebody to come. That be on it. Just a minute. What is that? Build it right. I can't build it. Come this side. Yeah. Please continue.
23/11/2023.
Speaking order,
Yes.
page?
That's not annexed, my lord.
Oh, not annexed.
Not annexed. I have it. In fact, my lord,
What does it say?
my lord, the provincialization of the petitioner's claim was rejected, my lord.
Oh, it was rejected.
It was rejected. But as, my lord, there is a direction, my lord, in the form of a mandamus, my lord. In the order, we had filed this review application.
Have you challenged this speaking order?
No.
First time.
First time you're coming across?
Yes.
What's It's 23/11/2023. Speaking order dated. You did not communicate this to them.
No, in fact, it was placed before the contempt court, my lord. My lord, the view of the court was, my lord, there is a mandamus, my lord. And therefore, the opinion was sought from the Senior Standing Council. And as per the opinion of the Senior Standing Council, the government has instructed the review petitioner to file a review, my lord.
Of course, that is what you just read. My question was otherwise. Have you served a copy of the speaking order?
Perhaps.
Then why do you write like this, copy to the petitioner Srimati so and so, without giving a copy?
But that I do not know, my lord,
Should
because
have given a
my lord,
copy.
this is a copy, my lord. It was produced to us when the contempt was listed, my lord.
If you don't intend to give a copy, don't mark copy to so and so.
Well.
You have already marked copy to so and so and without giving copy. Okay, then tell me.
Now, my lord, this review is being sought, my lord, on two grounds, my lord.
Yes. what
One,
is
my
that?
lord, the contention of the petitioner, as that is reflected in the order, my lord,
Hmm.
that the district scrutiny committee recommended the claim of the petitioner, but nothing had happened, and therefore this honorable court directed to bring the DLC's recommendation to a logical end. Now, my lord, if your lordship kindly finds the writ petition, my lord, the paragraph 9 of the district petition. Based on this contention, the honorable court had made that observation.
So you take me to the grounds of your review.
No, I'll take, my lord. That will, my grounds is from paragraph 9.
Your grounds are not clear.
No, it's very clear, Miller. If your lordship will see my grounds of the review petition, that which I'll,
Page 10.
which have page 10
How many grounds? A, B, C,
up to E, Miller.
A, B, C, D, E.
E.
Can there be so many grounds for a
F.
Miller,
A
the-
to F, my lord.
F to F.
There'll be
There are-
one or two valid points. The others are all decoration.
Yes. Usually it happens in every
Ah.
appeal petition.
So tell me, go straight to the meat of the matter. What is the ground? Specific ground.
Page 12,
Hmm.
F.
Yes.
Further, the Honorable Court referred to the recommendation of the DSC recommending the respondent for provincialization in Jungle Block High School and thereby directed the Director of Secondary to Education Assam to bring the recommendation of the DLSC made in favor of Marjan Begum to its logical end by passing an appropriate order. Whereas there was no DSC minutes available in the record, but from the order dated 30/07/2016 passed by the Inspector of School Nagaon, it appears that the DSC resolved only that the provincialization of services shall be on the basis of seniority in respect of respective category in the concerned school, irrespective of any subject combination, and accordingly directed the Inspector of School to pass a speaking order, and thereafter a speaking order, Annexure 7 of the writ petition is passed, and there is no recommendation of the DSC on record as per the order, and thus there is an apparent error on the face of the record, which warrants review of the order dated 28/10/2021.
Let us go to Annexure 7.
Yes, that what I intended to show first, paragraph 9, Miller. This is paragraph Annexure 7
Hmm.
is in support of the pleadings at paragraph 9. Page 29, Miller.
Hmm. Yes.
That the petitioner begs to state that finally the Honorable Court by an order dated 23/11/2015 has been pleased to dispose of the writ petition directing the district level scrutiny committee to examine the case of the present petitioner and the respond number 7 within a period of 2 months from the date of submitting the certified copy of this order passed by this Honorable Court. Thereafter, the DLC in its meeting held on 11/2/2016, my lord, kindly mark this date, examine the grievance of the respond number 7 and resolve that as per provisions of section 4(2) of the Assam Venture Education Institution Act, Amendment Act, the provincialization of service of the employees shall be on the basis of a seniority only in the respective category in the concerned school, irrespective of any subject combination. Thereafter, the DLC recommended for provincialization of services of the present petitioner and Abdul Khalik as assistant teacher of Jungle Block, and thereby DLC held that the respond number 7 is not entitled for provincialization of his service. The said school, since he is the junior most science graduate teacher among all 3 teachers, in the said meeting DLC dated 11/2/2016, the DLC directed the respond number 5 to issue a speaking order in this regard, and accordingly respond number 5 issued an order dated 30/07/2016 recommending that the service of the present petitioner and Abdul Khalik may be provincialized as assistant teacher of so-and-so school. Now, my lord will find page 52 is the order dated 30/07/2016.
Hmm. Yes.
Seen the order dated 23/11/2015 passed by the Honorable Court in WPC number so-and-so filed by so-and-so, the DLC Nagaon in its meeting resolved that as per provision to section 4(2) of the Act of 2011, the provincialization of the services of the employees shall be on the basis of seniority only in the respective category in the concerned school, irrespective of any subject combination. Now, the Honorable High Court has disposed the writ petition directing the District Scrutiny Committee to dispose of the petitioner's grievances within a period of 2 months from the date of receipt of the certified copy along with the copy of the writ petition. The District Level Scrutiny Committee in its meeting directed the undersigned to issue a speaking order on the basis of the proceeding of the meeting dated 11/2/2016. So, my lord, this speaking order is based on the minutes of 11 to 2016. 11 to 2016 is not on record, my lord. Was never a part of the repetition. Accordingly, the DLC perused and seen all records pertaining to the petitioner grievances and also re-examined the records, particulars and the staff pattern submitted by the headmaster in prescribed format to the District Scrutiny Committee for provincialization of the service of Abdul Khalik BSc Respond number 6, Marjan Begum BSc Respond number 7 and Mohammad Ahmed Ali Talukdar petitioner. It has been found that the date of joining of Abdul Khalik is so-and-so, Marjan Begum is so-and-so and Ahmed Ali Talukdar is so-and-so, which reflects that Mohammad Ahmed Ali Talukdar is the junior most teacher among them. Hence, the service of Abdul Khalik and Marjan Begum may be considered for provincialization. So there was no recommendation by the DSC for considered provincialization. It is by the inspector of school, by the speaking order, he has determined the seniority and he has recommended for
Where is this proceeding of 11 to 2016?
the original record. My lord, there is one more interesting thing, my lord. Your lordship wanted to see the original record.
11 to 2016.
11 to 2016. The original records your lordship wanted to see. My lord, in fact, the order dated 37/2016. In the original record, my lord, this is an order of 16/07/2016. There is no order as such 30/07/2016. My lord, you'll see, my lord, there are two flag marks, my lord, pink flag. My lord, the first pink flag your lordship will find, that is this order, my lord, at page 52, where the dates are different, my lord. Contents is same, my lord, I have tallied it.
This is a type copy.
This is a type copy. Original your lordship will find at 54. These are the documents of the writ petition, my lord.
Okay, then
Now 11 to 16 is the second, my lord.
Flag.
Second flag. My lord, one more interesting thing is, my lord, there are two signatures of two officers, my lord. One is the deputy commissioner and the other is the inspector of school, my lord, which also does not tallies with the composition that is prescribed for the district scrutiny committee under the act.
but where is the date? 11 to 2016.
2016.
There's an overwriting also.
Yes, perhaps.
Overwriting.
Yes. In fact, the other day when I placed the Xerox copy of this records, lordship wanted to see the original to see that whether there isn't any overwriting in the original. It is there in the original also.
It was earlier, I don't know, what is the date?
11 to 2006.
11 is written over 09. I think it's 09.
I think that the order was prepared on 09. When it is signed, it is 11/2. Therefore, the dates were put 11/2.
Okay, 09 and 11 overwriting is one thing. But then why is there another overwriting in the month and the year also?
Sorry.
Month is 02. That means February. 0 is perfectly okay. 2 is written or traced with pen again. Then 2016. 201 is okay, but that's 6. 2016, that 6 part again, it is traced by pen again.
Yes.
Why is that?
In fact, my lord, that is why, my lord, the
Now,
report was called from the inspector. And my lord,
this
if your
will have to
lordship will
tally-
see the signatories also, and if your
No,
lordship kindly
Mr.
see,
Kaushik, just
my
a
lord,
minute.
my lord.
This document will have to tally with the note sheet. Where in the note sheet has it been mentioned about this document?
No, it's not there, my lord.
Then?
But therefore, my lord, therefore,
So
we
this
have
will-
said that there is no recommendation, there is no report of the district scrutiny committee, my lord. That's what ground F
Whose
is
record is this?
our record, my lord.
Our record means who?
The-
Which authority?
The inspector of schools.
Inspector of schools. So as per the procedure, there'll be a note sheet and there'll be
And in fact, the
documents.
note ship, my lord, I have gone
So
through.
where in the note sheet has it been mentioned about this document?
No, it's not there. In fact, in the note ship, my lord, one very interesting thing.
So how do we rely upon this?
Yeah, my lord, it's the contention of the petitioner, my lord, that the district scrutiny committee recommended them on 11 to 2016, and based on which a 37 2016 order was annexed with the writ petition, my lord.
Leaving aside the contention of the petitioner, please explain your own record.
My lord, from my record, my lord, what I am trying to show is, if your lordship will see the note sheet, my lord, in 2015, the district scrutiny committee was dissolved. And it's very surprising, my
No,
lord,
no,
how
Mr.
thereafter.
Kaushik, you just answer my query, that's all. This record is neither here nor there. The note sheet has to correspond with the other documents annexed. So where is the explanation?
The note sheet, my lord, reflects about that order, my lord.
Where?
May I just point out? I'll just.
You have understood now what I'm saying?
Yes, yes.
Note, the document is at page 37.
Yes, page 30.
Where in the note sheet has it been connected to that page?
Like a.
Yes. Abdul Khalik and Marjan Begum, they are both science. They are both science teachers.
Yes. The green flag is the, my lord, the note sheet, your lordship will see. It's 4 to 2016 for placing it before the district scrutiny committee. Now, if your lordship will kindly refer to the pink flag, my lord, 1 and 2. This was, my lord, this first note for constitution of a district scrutiny committee, my lord. And your lordship will find there one statement, my lord, that the district scrutiny committee was dissolved.
Dissolved with effect from 15/8/2014.
14. And therefore, my lord, after this order was passed, but in my understanding, my lord, there ought to have been a new district requirement of a constitution of a new district scrutiny committee. But that was dissolved. But there is a condition attached, my lord, only in respect of only in respect of the court cases, my lord, the district scrutiny committee will consider, my lord.
So if the district committee is dissolved, then what is this proceeding?
Well, this 11/2/2016,
This was in view of the court's direction.
in view of the court's direction.
Hmm.
And if your lordship will kindly see the 11/2/2016, my lord, that this was signed by the deputy commissioner and the inspector of school. Now, if your lordship will kindly take page 659 of this book, my lord.
Page?
659 of the manual, my lord, education manual.
So before coming to that,
My lord.
where is this proceeding? Meeting dated 11/2/2016.
Nothing is there, my lord, in the office note, my lord.
Then why this order was passed then, if there's nothing?
That's very surprising, my lord. In fact, my lord, the ground F which I have read, my lord, that is what our ground of review, my lord. There is no record of district scrutiny committee, my lord.
Generally, the district scrutiny committee was dissolved,
Yes,
isn't it?
yes.
And the reason behind was? Because of Government of Assam Department OM number so and so dated. 36/2014. What is this OM?
Hello?
Office Memorandum 36/2014.
36/2000. I'll have to check, my lord.
What is the name of the school in which the petitioner working?
Jungle Block High School. That name is not there, my lord.
Not there.
Not there.
So this dissolving of the district scrutiny committee, it's in terms of the government's OM
Well.
36/2014. So when the matter was taken up in the year 2016, the
There
order says
should
that,
have been a reconstitution of the district scrutiny committee.
but this is your order.
Well, my ground F, which I have read, my lord, we are very categorical about one thing, my lord, there was no district scrutiny committee's report or recommendation in favor of the petitioner. Now, my lord, this order, in fact, the repetition also does not contain any recommendation, my lord. But this honorable court, considering that page 52, that order of the inspector of school, arrived at a conclusion, my lord, there was a recommendation by the district scrutiny committee. So in my respectful submission, my lord, this is an apparent error on the face of the report. That the order.
No, you are producing your own order and saying that
My lord,
this order does
my lord,
not exist.
my lord, in the review, my lord, I know my scope is very limited, my lord. What I'm trying to show is the, the observation of the honorable court saying that there is the district scrutiny committee recommendation which has not been acted upon. Now, my lord, the writ petition in paragraph 9, I have read it, my lord, that the petitioner refers to a recommendation of district scrutiny committee of 11/2/2016 and an order of 30/07/2016.
Why? Because,
Because 30/07/2006
because,
speaks about 11/2/2016.
correct.
Now, my lord, I produced the
So this
record.
is not an order
No.
passed by the petitioner.
No, this is, my lord, the.
This is
I-
by your officer.
Correctly, my lord. But what I have produced the original record to show that 11/2/2016 also there was no recommendation.
He's your own officer. Somebody will have to take the
No,
responsibility.
my lord, 30/07/2016 also does not say that the DLC has recommended the petitioner, my lord.
Hmm.
30/07/2016 order at page 52. May I just read it once more, my lord?
I've read it.
It,
The
it
last
also,
part.
my lord, it also does not say that the district scrutiny committee recommended the petitioner, my lord.
It does not say so, but it says that the district scrutiny committee directed the undersigned
To pass a
to
speaking order.
issue a speaking order. on the
In terms
base-
of the proceedings of 11/2. Now,
And-
11/2/2016, your lordship has seen where the seniority was determined. Again, a decision was taken with regard to the seniority.
Where is 11/6/2016?
11/2/2016, my lord, the pink flag mark in the record. Second flag mark.
You have a copy?
No, my lord.
You don't have a
Given
copy.
the order. তারপর আপনার রিসিপ্ট থাকতে লাগবে আপনার রিসিপ্ট রাখতে লাগবে সেইটো সেফ সাইড স্যার মই কোৰ্টত যেতিয়া দেখাইছিলো তেতিয়াই কপি এটা বিচাৰি মই দি দিম দিয়ে লগে লগে দি দিছিলে আপোনাক সেইটোৱে মোৰ কপিটোৱে আপোনাক দিছো সেইকাৰণে দোকান নেক্সট লৈছো
Mr. Kaushik,
মেলো
this also says, I'll just read a line to you.
মেলো
As per the scrutiny record, so and so, so and so. Mohammed Ahmed Ali Talukdar is the junior most teacher. Hence, the services of Mahajan Begum, Abdul Khalik may be considered for provincialization. This is the exact word given in the order.
the 30/07.
Ah.
So, my lord, the 11/2/2016 has determined that as per section 4(2),
Hmm.
it is the senior, these two teachers are senior to Ahmad Ali Talukdar. And therefore, they may be considered. Now, it was placed before the inspector of school to pass a speaking order.
It was passed.
After this
Hmm.
speaking order is
Hmm.
passed, the district scrutiny committee has to recommend for provincialization to the director. There is no recommendation. And my lord, what I was submitting,
So
my lord,
that is why court said that you complete the process.
my lord, there is no district scrutiny committee's recommendation, my lord. My lord, the honorable court
Now,
took
how do
into
you say that it is not there?
the honorable court took
It
into
says-
consideration.
Hence, the services of so and so may be considered for provincialization.
Correct.
What is this? Is it not a recommendation?
No, my lord. It's
Then
not
what
a
is it?
recommendation.
Then what
Because,
is it?
my lord, this is not a district scrutiny committee at all. District scrutiny
No,
committee.
that's a different thing. It's not a discrete scrutiny at all, is a different thing. Then you should have challenged it by filing an appeal,
No,
not
Because-
by a review.
my lord, why I'm saying review, my lord. This honorable court, my lord, has gave a categorical observation that there is a district scrutiny committee's recommendation.
Because of your letter. Let us see the order.
My lord. Paragraph 4, my lord, page 61.
Page 61.
Based on this contention, my lord, this observation. The DLC upon such examination arrived at its conclusion that the writ petitioner Srimati Marjan Begum is senior to Muhammad Ahmad Ali Talukdar and therefore would be entitled for provincialization. The writ petition is instituted that nothing further has been done and the recommendation of the DSC made in favor of the petitioner had not been acted up. Considering the limited grievance, we dispose of the writ petition by directing the Director of Secondary Education to bring the recommendation of the DSC made in favor of the writ petitioner to its logical end by passing an appropriate order.
Okay, now what about the Act of 2011? What
My
have
lord,
you do?
my second ground, which I also,
No, please ask, answer the question. That's
my
all.
lord,
2011, you said it has been struck down.
struck down
When?
on 23/09/2016.
After the judgment?
No, prior to the judgment.
Prior to the judgment?
No, that is also, my lord, one limb of argument, my lord, that after the act is being
Date, give
struck
me the
down,
date again.
23/09/2016,
Passed in?
passed in
WPC 3190, my lord, 2012.
3190/2012.
Then why was this relied upon in this order?
In fact, my lord, this honorable court, in many of the cases, my lord, have passed such orders. Considering that a legal fiction is being created under Section 4, and therefore the persons have accrued a right under the Act of 2011. In my respectful submission, my lord, that is absolutely contrary to the principles that is laid down by the Honorable Supreme Court. In fact, in many of the cases, my lord, we have filed appeal and review in such case. And in fact, the
Any
similar
outcome on such appeal?
in one writ appeal, my lord, in division bench has said, once as the act has already been struck down, there cannot be any benefit under that act.
What is that?
My lord, in writ appeal 283 of 2019, my lord, in the last day I have given, my lord, I think the copy is
283 of?
283 of 2019. Purnavati Brahma.
It's here. Can you say the paragraph?
Yes, my lord. My lord, paragraph 9, my lord. Judgment date is 13/11/2019. So Lordship will kindly come to para 4 first, ma'am. Paragraph 4, my lord, the issue that we have heard the learned counsel so and so for the appellant. The contention of the learned counsel for the appellant writ petitioner essentially is that the law that the respondents are required to provide a teacher to teach Assamese language in every school. The said law has been violated by virtue of order dated so and so. It pleaded in the writ petition that the petitioner has already been treated as a language teacher in so and so school. Particulars of eligible teachers serving in so and so school for provincialization of service of teaching and non-teaching staff as per Act of 2011 has been sent to the respond number sent to respond number 2 by the District Scrutiny Committee of Kokrajhar District, showing the date of recommendation of so and so 1/1/1992. Now, my lord, will kindly see the list being recommended. My lord. That's a requirement in the statute, my lord. Having total number of enrollment so and so and the name of the petitioner as language teacher of so and so, designation of the petitioner as language teacher and date of joining with effect from 9/5/2001 and degree qualification as graduate teacher in arts has been furnished. Despite such recommendation by the District Scrutiny Committee, the petitioner had been taken out of the purview of the Provincialization Act of Services under the Act of 2011. It has been pleaded that the school had been provincialized by the government of Assam as communicated by the Deputy Director Secondary Education, but the name of the petitioner has been dropped in the said impugn order. So far it relates to the service of the petitioner. Consequently, it is evident that the Act of 2011 has been violated. Now, my lord will kindly come to page 9, paragraph 9, my lord.
Yeah.
The case as projected by the learned counsel for the appellant to the effect that the appellant was vested with right under the Act of 2011 on the date when the judgment was rendered in Chandan Kumar Neog Supra cannot be accepted. The very fact that the service of the petitioner had not been provincialized and therefore the writ petition was filed makes it clear that the case of the petitioner would not be covered within the four corners of the decision rendered in the review petition. Admittedly, the petitioner was not getting salary as provincialized employee. Therefore, it would be a fallacy in law and facts to consider that the right had already been vested in the writ petitioner under the Act of 2011, which admittedly has been struck down as constitutionally invalid. The review court has held that the doctrine of prospective overruling would also not apply as the said power is vested only with the Supreme Court of India. It is in such circumstances it has been provided in para 19 supra of the judgment rendered by the review court that the right of the employees who have been benefited under the struck down statute can be taken care of by the retrospective effect of the proposed legislation if legislature so decide. Till then, it is ordered that the service of the provincialized categories and their status as government employees shall not be disturbed and they will continue to receive all benefits which they are getting under the Provincialization Act of 2011. Since struck down by the judgment under review, we are conscious of the fact that subsequently Act of 2017 was brought in place with effect from 11 April 2017. In the impugn order passed by the learned single judge, it has been said that no writ of mandamus can be issued in favor of the fact that the Act of 2011 is not in force. However, liberty was granted to the writ petitioner to approach appropriate education tribunal for consideration of her case for provincialization as per law in force. The respondents from Education Department were also asked to consider the case of the writ petitioner for provincialization under the Act of 2016-17 if she is entitled for the same in terms of the provisions of the Act of 2017. Since the Act of 2011 was held constitutionally invalid as noted above, we find no reason to differ with the view taken by the learned single judge. In fact, my lord,
What is that case by which it was struck down?
Chandan Kumar Neupal
Decided on which date?
decided on 23/09/2012. 16, sorry.
So what is the sum and substance of this appeal?
Well, the finding of the honorable
That it
single
has
judge,
already been struck down, so no benefit. will
there
arise.
cannot be any benefit given under the Act. Well, in fact, this is a, but in fact, the other day, if your lordship has it, well, there is one Supreme Court judgment which I relied on, my lord. Said, my lord finds the state of Manipur versus Suraj Kumar Okram.
Was it supplied to the court?
I think, yes,
I don't find it.
I have a copy.
So what is here?
It's a constitutional based judgment, my lord, that the Honorable Supreme Court
Tara?
Well. paragraph 23 first one.
Yes.
An unconstitutional law, be it either due to lack of legislative competence or in violation of fundamental rights guaranteed under the Part 3 of the Constitution of India, is a void ab initio. In so and so, it was held by the Constitution bench of this court that the law-making power of the state is restricted by a written fundamental law, and any law enacted and proposed opposed to the fundamental law is in excess of the legislative authority and in thus a nullity. A declaration of unconstitutionality brought about by a lack of legislative power as well as declaration of unconstitutionality brought about by reason of abridgment of fundamental rights goes to the root of the power itself, making the law void in its inception. Now, my lord, the principle that has been laid down is in paragraph 28.
This is regarding what? Legislative competency.
No, my lord. Once the principle that has been laid down in this case is, my lord, once the act is struck down, declaring unconstitutional, these are the principles which have to be followed, my lord. Paragraph 28, my lord. The principle that can be deduced from the law laid down by this court as referred to above are: a statute which is made by a competent legislature is valid till it is declared unconstitutional by a court of law. After declaration of a statute as unconstitutional by a court of law, it is nullest for all purposes. So, my lord, I'm relying on this second one, my lord.
Right.
So, and considering this, my lord, there is a judgment of the coordinate bench of this honorable court, my lord, where a similar issue was decided by this honorable court that after the act is struck down,
Case.
it's WPC 1694/2021. Well, this honorable court in this judgment has distinguished the two judgments that has been passed by this honorable court. One, my lord, that the right under section 4 of deemed provincialization would only accrue when there is a compliance of section 10(4) of the act.
Section 10(4) of what?
10(4) of the Act of 2011. Because merely by a recommendation, there is no right vested to claim section 4 benefit, deemed provincialization. Section 10(4) prescribes the entire procedure of provincialization, madam.
Deemed provincialization has been given, has been observed herein in order to give the retrospective provincialization. Otherwise, there's a second part.
That's a
The
second.
first part was that bring it to a logical
Logical.
conclusion.
And according
That
to
means
us, madam,
provincialization will be from the date of passing the order.
passing the.
Now, to
According,
make it retrospective, this deemed provincialization of Act of 2011 has been relied upon, correct?
yes,
In two parts.
in two parts.
Hmm.
Madam,
But insofar as the first part is concerned,
in the first,
you said there is no recommendation,
There's
but
no
there's a recommendation.
madam, that's, madam, even that is not, madam, my contention is
Hmm.
that the 11 to 16 minutes,
Wow.
madam, cannot be said to be a minutes of the district scrutiny committee.
Why?
Madam, the act provides,
Composition again.
composition
You
of
are
the
in
district.
composition.
madam,
Are
because,
we to look on the composition on this at this stage?
yes, madam,
This
because,
is not an appeal.
no, of course, madam, the observation of the court
Hmm.
that there is a recommendation. Madam, in fact, madam, even if it is assumed, madam, this 11 to 16 is a recommendation, it is not a recommendation of the district scrutiny committee for provincialization, madam. It is a determination of the seniority among the inter-se seniority among the parties, madam.
That is there.
Yes, that is what, madam,
And it doesn't stop there.
madam,
It
it
does not
says
stop there.
it
says
says that it may be considered. Madam,
Hmm.
district scrutiny committee has to recommend.
Hmm.
They cannot make an observation that it may be considered.
Hmm.
Because that is a statutory authority which at the inception has to recommend it to the director.
No, let us not delve on the language part. I
Huh.
think it's a recommendation.
Rightly
Rightly or wrongly, it's a recommendation. And if you doubt the language, if you doubt the constitution, I don't think this is the right place to argue on that point. And in respect of the other thing, maybe you have a point. If it's a
Well-
struck down
Yes.
law, then that benefit of retrospectivity may not be applicable.
There cannot be
Because-
any mandamus with regard to that
Ah.
under the act.
That much. the court may look into. But beyond that, I don't think. Let me hear the other side.
In fact, my lord, the judgment which I have placed right now, my lord, if I may, allowed to, my lord.
Yes, why
Make
you are
a-
relying
yes.
upon this judgment?
Yes, yes.
What was the issue?
My lord, the issue was with regard to, my lord, claim for deemed provincialization, my lord. Relying,
Is it relevant to your subject? This
yes, my
subject?
lord, yes.
Relevant.
Yes. My lord, the honorable court in my lord, the order which I am seeking a review, my lord, has made an observation that as the district scrutiny committee has already recommended, therefore, he would be entitled for provincialization under section 4. Now, my lord, this merely because the district scrutiny committee has recommended, my lord, that is what, if your lordship accept that this is a recommendation of the district scrutiny committee, then also, my lord, the section 4 benefit would not be accrued upon them. Firstly, because the act has been struck down. Secondly, because the recommendation of the district scrutiny committee will not confer any right upon the petitioner to claim deemed provincialization, because the process that has been decided by this court in two judgments, my lord. One in Deepak Das, my lord, where this honorable court has said that the act prescribes a procedure for provincialization. District scrutiny committee will recommend it to the director. Director will further verify and scrutiny it, and it will send it to the government, and government will issue the notification. Unless the entire procedure of 10(4) is completed, there cannot be any vested right under section 4.
That was the requirement that you had to do.
That we have to.
Instead of filing a review petition, you
No,
should have done that.
My lord, because of this mandamus. My lord. Otherwise, the speaking order which we passed it in that line only.
But one thing is now difficult in the sense that this speaking order,
No, I'm not placing that speaking order, my lord, because ultimately, my lord, we have challenged this order, my lord, on the grounds that has been enumerated in the review petition.
so will not refer to this speaking.
No, my lord, no. That was for the purpose of the contempt, my lord, where
Yes. You need not argue elaborately. I have expressed my mind, although I have not made any definite conclusion.
Yes, my lord.
But you don't have to begin from
The point my
the
learned
A to Z.
my learned friend, you know, certain facts, my lord, has not placed before the court. My first leg of argument would be on maintainability of the writ petition, my lord.
Writ petition.
Sorry, a review.
Okay.
Review on maintainability ground, my lord.
Why? Why?
Because, my lord, the file between, my lord, is the order passed on 2021. Then we prefer 2020. In presence of the both.
No, in short, on delay.
Yes,
Okay.
my lord.
Then what is the other submission?
Second, my lord, the grounds for entertaining the review petition, the conditions, my lord, to entertain review petition, that would be absent by learned friend, the commission made by learned friend, my lord. The certain
Okay.
points, if you satisfied, then reviews maintainable.
Okay.
Okay. Then my query is to.
Order 47.
Yes, I'll come, my lord. Then, my lord, in this matter, my lord, admittedly, my lord, my learned friend has projected some case my different angle, my lord. Admittedly, my lord, I mean, the whole stuff, teaching and non-teaching stuff from my concerned school, my lord, already, my lord, sanctioned all the posts, my lord. Then when my event, in the website, my lord, my school, my name was forwarded for the eligible teachers who are eligible for the provincial election, my lord. Suddenly, my lord, one junior most teachers approached before this court challenging that our two teachers post, science teachers post, and then this honorable court has state the interim state on basis of interim state, my lord.
There you go, Mr.
Yes, my
Counselor.
lord. I'll take this all.
You don't take me everywhere. This is a review petition.
Yeah.
We are
No,
not
in review-
rehearing the matter.
In review petition, those documents, my learned friend.
That's why I asked Mr. Kaushik also to point out the main ground of your review.
Yes, my
We'll
lord.
stick to that only.
Yeah. My lord,
Nothing more.
my lord, before taking to them, my lord, only 3 documents I'll have to show your lordship, my lord.
What
Then-
document?
Yes, my lord. How I'm entitled, how I'm eligible, when my case is wrongly projected by the review petition, it is very important, my lord. they have enclosed those important documents. We have enclosed my writ petition, my lord. Kindly have in a review petition itself, my lord. Kindly, my lord. I have filed one in review petition, my lord. I have affidavit, my lord.
Now, what is that document? You tell me like that.
First document, my lord, that interim order passed by the Honorable Court.
Ah.
Next document, my lord, provincialized all the teaching staff keeping vacant of that one post of science teachers, my lord.
Mm.
Then finally when decided disposed by this Honorable Court, my lord, only decided, my lord, who is eligible, who is entitled for this court. Only that point, my lord, and on this relying on this Honorable Court order, that is on 37/2016, that order passed, my lord, Inspector of School, my lord. So
Okay. See, I think I've
my
heard. the
case is,
parties-
my case is, my lord, whether I am eligible for provincial, this is not, who is senior most teacher, who is, that is the only question involved here. My learned friend newly case in the as if I am applying for the new provincial.
All right.
No, my lord.
All right, we'll pass the order. Heard Mr. B. Kaushik, learned counsel for the review petitioner. How many? One petitioner or
One.
review petitioner and Mr.
Yeah, PK,
P.K.
Deka,
Deka for the
sole respondent.
sole respondent oblique writ petitioner. Stop. This review petition has been preferred, seeking review of the order dated 28/10/2021, passed by this court in WPC number 462 of 2020. Stop. Although the review petitioner has raised six grounds for review of the order, but the main ground for review is found in ground number F.
And B, my lord, the second.
Okay, ground number B and ground number F.
B, C, D are my lord same. D is that, that until the 10-4 is complied with, there will be no vested right under section.
Stop. Ground B and ground F are abstracted here under. For ready perusal. A to A. Page 10 and page 12. Next para. It may be seen that this court, accepting the contention of the writ petitioner, that the earlier writ petition, that is WPC number 5330 of 2012, filed by, who was the petitioner?
That petitioner, my lord.
Filed by
The respondent.
Mohammed Ali Talukdar, correct?
Yes, yes. The earlier petition.
Yes.
Mohammed Ahmed Ali Talukdar.
Talukdar.
Please read the sentence. Was disposed of by order dated 23/11/2015, directing the district level scrutiny committee bracket DLSC to examine the claim of the rival parties and reach a conclusion. Was acted upon by concluding that the respondent was senior to Mohammed Ahmed Ali Talukdar and was therefore entitled for provincialization. Directed that the same be brought to its logical conclusion by the aforesaid order dated 28/10/2021. Further, it was directed that as it was a case of deemed provincialization under section 4(1) of the Assam Venture Educational Institutions, open bracket, provincialization of services, close bracket, Act, 2011, bracket, Act of 2011, close bracket, comma. The instant respondent would be entitled to be given the benefit of provincialization from 1/1/2013, subject to fulfillment of the requirement of section 3 of the Act of 2011. Stop, next para. Now, the review petitioner has come up with this review on the ground that there was no recommendation made in favor of the petitioner in the proceeding of the DLSC meeting minutes dated 11/2/2016. And therefore, the order should be reviewed. Stop, in support of such contention, Mr. B. Kaushik, learned counsel for the petitioner, has produced the relevant records of the department and submits that there was no such recommendation by the DLSC when it met on 11/2/2016. Stop. He also submits that the composition of the DLSC is also not in terms of the
10,
which provision, which act,
2011 Act,
which was struck down,
which was struck down.
in terms of the provisions of the Act of 2011. Stop. He submits that unless there is a specific recommendation made by the constituted DLSC,
DSC, District Scrutiny Committee, DSC.
but this is District Level Scrutiny Committee, Nagaon.
Under that act, it was called as District Scrutiny Committee. That's the confusion, my lord. In 2017 Act, it is District Level Scrutiny.
Oblique DSC, and thereafter submitted to the government. Is it?
Director.
Director will do what?
The District Scrutiny Committee will recommend to the director. Director will further scrutiny and examine, and then they will recommend it to the government for issuance of notification.
To the government through the director of the department. Then only the question of provincialization of service would arise. Stop. However, in the instant case, since there was no recommendation, the claim made by the petitioner being based on wrong presumption, the order sought to be reviewed should be accordingly reviewed. Stop. Next para. The Mr. B. Kaushik further submits that since the Act of 2011 has been struck down by this court by judgment and order dated 23/9/2016 in WPC number 3190 of 2012. The benefit of deemed provincialization with effect from
1/1/2013.
1/1/2013 cannot be given to the respondent oblique writ petitioner. Stop. Therefore, even on this count, the order should be reviewed. Stop. The learned counsel also submits that although the order was passed on 28/10/2021, review petition could not be filed immediately. And explanation for such delay has been stated in paragraph number 10 and 11 of the review petition. Stop. Under the circumstance, the learned counsel submits that the review petitioner may be allowed as paid for. Next para. Per contra, Mr. P.K. Deka, learned counsel for the respondent, submits that the review petition is not maintainable on grounds of delay and having regard to the principles governing the grounds for filing a review petition. Stop. He submits that the explanation tendered by the review petitioner that there were certain circumstances due to which the review petition could not be filed on time is only an afterthought. To stop. He submits that the respondent oblique writ petitioner, due to non-compliance of the court's order, had filed a contempt petition, and the review petitioner, therefore, faced with the contempt petition, decided to file the review petition. To stop. The review petition should therefore be dismissed on grounds of delay and laches. Next para. Mr. P.K. Deka, learned counsel, further submits that in order to make out a case for review, there has to be a mistake or error apparent on the face of the record, which despite due diligence was not brought to the notice of the court at the time of filing, at the time of passing the order. To stop. In the instant case, from the grounds taken by the review petitioner, it clearly appears that there is no error apparent on the face of the record, and the grounds taken for review cannot be considered to be grounds for reviewing the order passed by this court in the writ petition. Stop. Therefore, even on this ground, the review petition should be dismissed. Next para, Mr. P.K. Deka, learned counsel for the petitioner, further submits that the respondents, no, the inspector of schools, Nagaon District Circle, Nagaon, had issued an order dated 30/7/2016, wherein it was clearly indicated that he was authorized to pass a speaking order pursuant to the meeting of the DLSC on 11/2/2016. To stop, it was clearly indicated that the respondent oblique writ petitioner was found to be senior. To one Mohammed Ahmed Ali Talukdar, and therefore she and Abdul Khalik were recommended for provincialization. To stop, despite the same, since no steps was taken in furtherance of the recommendation, the respondent oblique writ petitioner was compelled to approach this court through WPC number 462 of 2020. The writ petition was accordingly disposed of on 28/10/2021 with specific direction to the respondent authorities concerned. And therefore, it is only incumbent upon the part of the authorities concerned to comply with the same. Stop. Under the facts and circumstances, the learned counsel submits that no grounds for interference is been made. No ground for review is made to the order dated 28/10/2021, and the instant review petition should be dismissed. Stop. Next para. I have heard the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record, including the record produced by Mr. B. Kaushik, learned counsel for the review petitioner. Stop. Although Mr. B. Kaushik, learned counsel, submits that no recommendation has been made by the DLSC, but on perusal of the records, it is seen that the DLSC, which met on 11/2/2016, upon perusal of the records, came to the conclusion that the services of Marjan Begum and Abdul Khalik may be considered for provincialization. And accordingly, the Inspector of Schools, Nagaon District Circle, was directed to issue a speaking order on the basis of the proceeding of the meeting of the DLSC. And in compliance of the court's direction passed in WPC number 5330 of 2012. Stop. Although an attempt has been made by the learned counsel that the very composition of the DLSC is defective and it cannot be considered as a and it that can it cancel, and the so-called recommendation cannot be accepted as a recommendation to take up the matter for further process. But the fact remains that such a submission in the considered view of this court cannot be a ground for not accepting the meeting minutes when we are concerned, when the court is looking at a review petition, when the court is considering a review petition. Stop. No materials have been placed before the court that the order passed by this court has been challenged before a larger forum. And therefore, in absence of such a challenge, the order issued by the Inspector of Schools, Nagaon District Circle, on the basis of the authorization given by the district level scrutiny committee, would be justified. To stop. Therefore, review sought for on this ground in the considered view of this court cannot be accepted, and accordingly the same is rejected. Stop. Next para. In regards to the second ground taken by the review petitioner, that the Act of 2011 having being struck down by this court, the same cannot be justified, comma, this court is of the view that striking down of the Act of 2011 has preceded passing of the order dated 28/10/2021 sought to be reviewed. And therefore, having regard to the decision of the apex court in this regard, as relied upon by the learned counsel for the petitioner, that is State of Manipur and others, versus Surja Kumar Okram and others, reported in 2022 SCC Online SC 130, comma, the same will have to be recalled. Stop the apex court in the given facts and circumstances that of that case held that the statute which is made by a competent legislature is valid till it is declared unconstitutional by a court of law. Stop further. After declaration of a statute as unconstitutional by a court of law, it is none as for all purposes. Stop the aforesaid principle would squarely apply to the instant case. Stop therefore, insofar as the direction made for giving the petitioner the benefit of provincialization with effect from 1/1/2013 in terms of the Act of 2011 stands recalled.
My lord, I have one more submission, my lord. Therefore, in my application affidavit, my lord, on some Sanskrit teachers, my lord, they approached before this court in the 2016, my lord, saying, my lord, the single benches directed to provincialize them as per applying the Act 2011 Act. Then ultimate case goes to before the Supreme Court Honorable, and Honorable Court on 12 of 2024, this single bench judgments affirmed, my lord, yes, there are 2011 benefit they are entitled, my lord. That order I have enclosed here. My learned friend relying to Honorable Act of 2022. Here, my lord, 2024 judgment I have annexed, my lord. Kindly, my lord, that observation, my lord. I have annexed here, annexed.
I've already made a decision.
My lord, this observation, my lord, has to be brought on record, my lord.
Now, how do we make that observation?
Yes, my lord. Kindly have a look at page, my lord, 239 of my affidavit in the review application. To 39, my lord, that is order passed by this honorable court on 25/5/2016, my lord. See. Page 239.
Annexure 8.
Yes, my lord. Annexure 8 and Annexure 9 of the Honorable Apex Court order, my lord.
This is not by apex court.
2000, Annexure 9 to 42 is the Apex Court. Ultimately, this single bench goes to Supreme Court, my lord. Then
Which paragraph? Point
yes,
out.
my lord. My lord, page 241.
241 is a judgment of this court.
Single, yes, my lord. This order by Honorable Apex Court 2024 affirmed, my lord. Then these are Sanskrit teachers, my lord, and they were not provincialized. Then approached this court, and this honorable court held, my lord, paragraph 28, my lord, 241. Huh? No. Yes. And Apex Court finding.
Mr. Counsel, I think that is enough. This order is dated 25/5/2016.
And so
We're talking about the striking down of the order by order dated 23/9/2016.
prior to that,
Subsequent.
prior to that, 2018, this order passed, my lord, on 25/5 before striking down of the.
That is why the benefits.
Then, my lord, my
After striking down, you get no benefit.
my lord, this
Simple
order,
as that.
my recommendation done before striking down, my lord.
With the above observation and direction, the review petition stands disposed of. Yes.
Bless me.
You take back the file. Mr. Kaushik,
My lord.
your reports.
First, my lord, the writ petition has to be restored back, as your lordship has recalled that order.
How?
The review, my lord, your lordship has recalled that order.
Those recallments, the writ petition was disposed of.
Yes.
isn't it?
Now the order.
There
has
are
been-
two parts, two direction was there. One has been rejected, the other one is recalled, that's all.
Well.
Where is the question of restoring it? I don't think that there's a issue of restoring the writ petition now. And restore and do what? For fresh education?
Yes,
Cannot be.
because the order has been recalled. Well.
No, I have
Though,
expressed
my
the opinion that
Yes,
it cannot
though
be.
your lordship has not accepted one ground of my.
I have not
review.
accepted because it has been struck
Yes, yes,
down.
I'm not on that, Mala. As the lordship has, among the two grounds,
Hmm.
lordship has accepted one ground.
Hmm.
Now, Mala, as this order, the order passed in the which is under review, Mala,
Hmm.
that order has been recalled. So perhaps it requires a fresh adjudication in the writ petition. Mala.
Doesn't require. I have rejected it. You must have heard it. Yes. 5 minutes.
For petition item 1.
May it please your lordship. Lordship, hearing this.
Yes.
Record to please pull for procedure. Lordship, hearing this matter, lordship, I was supposed to produce the records, lordship. Lordship.
Okay.
Records.
You don't have the records?
Yes, lordship. So lordship, after a week, any date, lordship, I'll get the records. Lordship.
What is this matter regarding otherwise?
My lord, this matter otherwise, my lord, is regarding the appointment of a lecturer in a college, my lord.
Hmm.
The main grievance of my in the entire writ petition is that my candidature was struck down on the ground the official NOC did not reach the selection body.
Hmm.
Earlier, my lord, now this scene is gone because of this lots of hue and cry. Earlier, what used to happen, my lord, I used to get the NOC from the concerned IS.
Hmm.
And that NOC is submitted along with my application.
Hmm.
Another official NOC, that is the school, suppose I am a serviceman and I am working in a school. Through the school authority, it goes to the IS that please give him the NOC, he wants to appear for that post. Then IS sends an official one as an NOC. But it is, my lord, settled rather in a manner like if the NOC is given by the applicant along with his application, that is considered. And because that official one, it goes by post, it may not reach at the time.
Where are you working?
I'm working in a high school.
So you have to get NRC from the high school headmaster.
I already got it,
Hmm.
but that according to them, it reached later. But
You have applied for which post?
then I wanted to become a lecturer. I am now a graduate teacher in a high school.
You're a graduate teacher in the high school. You want to become a lecturer.
Lecturer in a college.
In a college.
College,
You applied for it and you're required to give NOC.
NOC. I've
And
given-
NOC has to come from the school or from the IS?
My lord, no. Normal feature is that suppose I am a working teacher, I apply before the school authority. School authority principal then sends it to the IS. IS sends the same to the concerned school, college.
Why all the roundabout manner like that?
Now it is gone, my lord. Now it is not there. Now you have to give it along with your application. But in that case, even I have given through my earlier it was in the two form. Whenever a teacher or a working person is applying, then along with his application, along with all application testimonials, he has to give the NOC. That is given. But another thing, it has to go via through proper channel.
Okay,
And that
okay.
goes by post.
Okay, what record is required now? Which record is required?
Lordship, that,
With regard NOC?
yes, lordship, because it
From-
will be there in the record. Lordship,
Record of whom?
of the petition.
IS.
No, lordship, the petitioner's record, lordship.
Petitions record. Who maintains that?
Lordship, it is in the department, lordship.
Huh?
Department. Lordship.
Department,
Higher
directorate.
education, higher education.
No, it is the college.
But lordship,
Because
the-
the college has given me the RTI reply saying that was already reached.
So,
My lord,
so why is there a controversy even regarding records? Then
The-
which record you will produce? Both parties don't agree of that record.
No. It was not me.
No, he's saying the record from the department. You're saying the record of department is not required. Record of the school, from the school.
School, because it college. It has to go to the college. And that is, I think, asked
No.
5 years back.
Just tell me in one word, which record is to be produced?
from the directorate, lordship.
Whose record? Whose record?
Lordship may have a look at the order dated Lordship 27/1/2021, Lordship.
You have to read, make me read some order. You cannot say that also. Which
Lordship, it
record
is
is
in the-
required?
Lordship.
Hmm?
The first order, Lordship, 2011/2020, Lordship. The,
For the record.
yes, Lordship.
So for 5 years, you could not produce the
No,
record.
it was placed, Lordship, and that, then subsequently, Lordship, on 27/1/2021, it was placed. But the second paragraph of the second page, Lordship, it states that the record shall be produced again at the time of Lordship, the next date, Lordship. But then, Lordship, this matter was not taken up, Lordship. So, Lordship, on 6/2, Lordship, it was directed.
No, no, I'm interested not in that, not in that. You tell me which record.
Lordship, it states that the
Only regarding
application
the-
of the petitioner for the selection process, which was routed through the proper channel, which in fact is the same authority, Lordship, has issued the NOC and that is available in the selection committee records, Lordship. So that record, Lordship.
Records of the selection committee
Yes, Lord.
of the post which you applied.
Yes,
Lordship.
in respect of that NOC, my lord. I think there. it
So
is
what,
mentioned.
what is the controversy now? Why they, why is the record
No,
required?
my contention before the honorable court
Hmm.
was that
Hmm.
that my NOC along with application individual NOC.
Has reached.
It's reached.
Is
It
reached.
is there.
Okay.
That is the reason they gave me the call letter. I appeared.
Mhm.
All on a sudden, my lord, during the interview process,
Hmm.
all on a sudden, one person just rose up and one of the member rose up and said, no, your NOC has not been received. I said, no, I have given the NOC along with my application. Question, no, you have to get your NOC through proper channel. Then I said the proper channel NOC may reach you later because it is coming by from your own department through postal. I'm not bothered about that, but what I have got from the same authority, the IS, and that is I'm already presented before the,
The NOC you presented was from the IS.
yes.
Inspector.
So what else
And
will come?
from the through proper channel also from the IS.
So IS will give two times.
Two types. Earlier it used to be two types, my lord. Means one individually you can collect, my lord. Sorry, my lord, I can collect. Another it has to routed through proper channel.
What is the composition of the selection committee? Are they a party?
Yes, my lord.
Respondent number?
4, Lordship. 4.
My lord, the selection committee, there is respondent number 4. Secretary cum principal. A principal I have given individually also. And my lord, now if there, my lord, only one thing to make it, if your lordship permits, my lord. Regarding that NOC, if your lordship has to be adjudicate whether the NOC is
We are
required,
not adjudicating anything
then my lord,
at this moment.
then.
Because the specific prayer was made that I want to produce the record. My question is which record, what record?
Yes.
And all of you started submitting roundabout. That is not required. Just get to the point.
The record, my lord, of the
Record of the respondent number 4.
Yes, record which is forwarded by this college selection board, my lord, to the director, that record will be produced by.
Okay, so record of the respondent number 4.
Yes,
Who will produce?
that the director. my lord.
You are for
And
the
college, my lord. We have already forwarded after the.
selection committee is constituted by the director.
College, which is as per the director gives the approval thereafter with the consultation of the
See, again,
university.
you're all going here and there. Selection committee
Yes,
for the
Lordship.
post of assistant professor botany
There's one
represented by the secretary cum principal of the college.
duty. Yes.
So who is keeping the record, the principal or the director?
It is forwarded to the director, my
It
lord,
has
the
been
all,
forwarded
all
to the
the,
director.
All the records?
yes. After the selection is over, it is forwarded.
Okay, Mr. D. Pomania, Learned Standing Council. What is this? Higher education.
Yes, Lordship, 1 and 6.
Higher education submits that he may be given 10 days time to produce the records of the selection committee for the post of assistant professor of botany
OB.
in the
Access College.
SS College, Hailakandi, which is Sri Bhumi now, isn't it? Hailakandi has become Sri Bhumi.
Can you
No,
put
no.
this?
Oh, Karimganj, okay, Hailakandi. Then No full stop, you continue. To enable the court appreciate the NOC submitted by the petitioner while submitting his application for appointment to the post in question. List again on so and so. Mr. D. Upamanya shall produce the records.
My lord, I have a, with your lordship permission, my lord, I have a small prayer, my lord.
What is that small prayer?
He is for the college, my lord.
Hmm.
If the college authority also has got also some documents left with them.
I don't know.
No, because from my lord, my
If,
lord,
if not, but all that, what is
no,
this?
no, because I got the RTI reply from the college. College is given the NOC which I have given.
You file your application. If you want to something else, you file your application. We'll consider that.
No, only thing.
No, orally, you cannot say if it is there, if it is not there, do something, don't do something. That cannot be, you cannot go on presumption like that. He will say that it is not there. The matter ends there. Give it in writing that this is what I feel that this is there and let them produce. Then we'll see, we'll direct it. List on so and so.
By the way, I've got no honey.
You have got your date, Mr. Abedin. Be satisfied. Normally, I don't give dates.
I understand.
You're getting date. Be satisfied. Next.
Item 2.
Lordship, this matter pertains to provincialization of service.
Mm.
My lord, I am the social studies teacher, my lord, in Haji Ismail Bhuiya Memorial ME School. ME
Yes,
Madrasa.
but there is no affidavit.
But my lord, Lordship can dispose of with the similar direction, similar in.
No, don't give me that. First, you explain what is this. You want to seek adjournment.
Yes, Lordship, we will file today.
You are for? You are for?
7 and 8.
7 and 8 respondent number.
Who is that 7 and 8?
Private respondent, my lord.
Private.
Whose service has been provincial. Both of them are language teachers, my lord.
7 and 8 provincialized.
Lordship.
So let them, we'll hear them also. Then government, department. You don't want to file affidavit. When will you file? Some request letter is required to file affidavit. Ms. Sutia. Then. No, but then at least you write something that we don't have anything much to say. At least something should be on record. So that we can proceed with the matter.
2022 matter, my lord.
Today we dispose the matter, then tomorrow the party goes and says that no affidavit file, please remand back.
My lord,
Again, back to square one.
Lordship, actually, there is a provision for appeal, my lord, under section 14. And this court, my lord, in earlier occasion, in similar cases. my
All right, you save up your argument for the next day. We'll give them one last opportunity.
Lordship.
Considering the prayer made by the learned counsel for the respondents, one last opportunity is granted for filing counter affidavit. Failing which, court will proceed with the matter in accordance on the basis of materials available on record. List again after 3 weeks.
Obliged.
Item 3.
May it please your lordship.
Yes.
My lord, this is also a matter of provincialization of the post of the petitioner, my lord.
My lord, in this matter, Ding Usare will appear, my lord, for the time being, my lord, kindly pass over the matter. And have 2 matter.
Who has filed affidavit? Petitioner.
Petitioner,
What affidavit have you filed?
my lord, lastly, one affidavit has been filed by this petitioner on 28, my lord.
Yes,
stating
why?
That
Why?
she was, my lord, attending the classes from 2006 to 2000, my lord, 25, no doubt, but records from 2010 to 2018 was available in the school, my lord. Therefore, with the attendance register, it shows that she has, as per the Act of 2017, it is 6 years, but the petitioner in fact has, my lord, completed 19 years, my lord. What happened, my lord? During this period, she was, my lord, attending one or two classes in a central school, my lord. In that school, my lord, after attending her classes, after completion of the classes in the school, my lord, this petitioner went there and a few classes taken without salary, my lord. Only
Your
per
case is
day.
for salary,
Now, this is, my lord, this repetition is regarding the provincialization of school.
provincialization.
Yes, yes. My lord, if your lordship kindly take up the repetition, my lord, because a respondent has filed 3 affidavits. This, therefore, my lord, petitioner has to file reply in 2 affidavits.
You want to file reply?
No, I have already filed.
Oh, you have.
It's, pleading is complete, so from my side, my lord. Now, your lordship may kindly turn to page Annexer 1. This is the appointment letter in 2006. At page, my lord, 17.
Any private respondent here?
No, no private respondent. Well, why the name was not considered? It is, my lord, in the 2 affidavits earlier filed by the respondent, it's no clear.
All right, let the council come. We'll hear both of you. Who's the council appearing? Is he coming?
Yes.
Okay, time being.
Timing. Obliged, my lord.
Item 4.
Lordship, this is regarding a non-payment of arrears salary on the basis of no work, no pay. There are several rounds of litigations happened before this honorable court, Lordship, where I was protected. And during that period, I was in the court. This will take little time, Lordship. Can it be fixed on Tuesday, Lordship? It has so many things, but it'll consume time.
Okay, Tuesday is a date on which I think we have fixed many cases also. Is it possible? 24 matters. Thursday? 21 matters.
Tuesday, Lordship.
Tuesday, you want to try your luck?
Next week, last.
And Tuesday is next week only. This week, no, there's no more Tuesday.
Yes.
Sorry.
Okay, at least on Tuesday as paid for
Obliged, Lordship.
by the learned counsel for the petitioner.
Item 6.
Hearing, my lord, matter pertains to my lord suspension, my lord. And in fact, notice was issued in this regard, but no affidavit was filed till date.
You are still under suspension.
Yes, ma'am.
Since when?
My lord, from 5/12/2024, my. Impugn order is there at page 17, lord.
Has it been reviewed?
Nothing. There in this.
So, Ms. Sutiar, what does it say?
Reviewed, my lord.
When?
Last on 20.
Then charge has been given, charge sheet?
My lord,
That's for my inspection.
Charge sheet given?
given, my lord.
You file affidavit
My lord, I will file it.
by Monday?
Lord.
Short affidavit regarding those documents?
Yes, yes.
By
not-
Wednesday, my lord.
Wednesday, okay. List on Wednesday. As paid for by Ms. S. Sutiar. To enable her to file the instructions she has received, which is to the effect that the suspension of the petition has been reviewed and charge sheet has been given to him.
Deep level.
6. Oh, 5th is all, 6, on 6th.
On C.
5th is a holiday. It's a Wednesday, isn't it? Wednesday is a holiday.
Obliged.
6.
No one appearing? Mr. B. Prokashta is there?
Lordship, may take up the item 3658 WBC, my lord.
Same petitioner,
Yes, Lordship.
3-6?
3658, my lord.
Hmm. Which one was filed first?
Two
2003 was filed first.
yes, it was filed first.
What do you say in 2003 is that,
Well, it is,
just listen, what you
is-
say is that, your ACR has been rewritten.
yes, it is.
So that's why you agree with that.
Yes, it is corrected.
It is not in your favor.
In my,
Rewriting of the ACR is not in your favor.
in my favor.
In your favor. Then you have no grievance if it's in your favor.
In 2003 case, it is, I have no grievance.
You have no grievance.
We have no grievance.
You want to
Because,
withdraw?
It may disposed of. Last occasion it is recorded that,
You want to withdraw?
it is resubmitted. Resubmitted by correcting the, my lord, if it is
No,
given.
2003, should it be kept pending or you want to not press it?
Yes, because my lord, they have resubmitted the, therefore it may be closed, my lord.
Okay. As paid
Is-
for by Mr. B. Prakashta, learned counsel for the petitioner, the writ petition WPC number 2003 of 2025 is closed as not pressed. Mr. U. Sharma, learned counsel, learned standing counsel, secondary education appears for the State Department. Okay, now you come to the other.
Yes, Lordship. In this case, my lord, what happened, this is a third round of litigation. First, I take your lordship to Annexure 1 is the seniority list.
One more line.
Annexure,
Let the matter be segregated from WPC number 3658 of 2025. Yes.
my lord, in this case, my lord, the seniority list is given at page 22. Your lordship will find.
This is on what? Seniority?
Yes, for the post of in charge principal, my lord, this honorable court has given twice the direction, my lord, mandamus. Instead of that, they are passing one after another impugn orders, my lord.
The subject matter is in charge principal
Yes.
of
Of higher secondary school.
higher secondary school,
Yes.
page 22. Yes.
Page
What is
20
this
This is
seniority list?
Yes, my name is Tonkeshwar Nath.
Oh.
You lordship will find in the page 23, serial number 5. Hmm.
Yes, so
Yes, lordship. Presently I am the senior most teacher of the school, my lord.
this arrangement of names is in by way of seniority?
No, no, no.
You are
This
in
is-
serial
this
number
is-
5
This is, I'm at serial number 5.
and respondent number 4 is in serial number 4.
Respondent number 4, Ratul Das.
Hmm.
Yes, because they are these postgraduate teachers, I am the assistant teachers in high schools, my lord. Therefore, before those who are postgraduate teachers of higher secondary sections, they are given 1, 2, 3, 4. Thereafter, high school sections have come. That is the thing. But the
Okay.
seniority is determined on the basis of the grade date, getting the date of graduate scale of pay.
And to be the in charge principal of the
To be higher secondary school, one must be the senior most, having the graduate scale of pay.
Mhm.
Bas, that is the thing, my lord. My date of getting graduate scale of pay, lordship will find at page 21, I am given 30/12/1993.
See, although you are assistant teacher,
Yes,
you can become principal
yes, yes.
in
Or-
the presence of graduate, in the presence of postgraduate teacher
Yes,
also,
yes, yes.
on the basis of seniority.
On the basis of seniority, and that seniority is determined on from the date of getting the graduate scale of pay.
Date of graduate scale of pay. What is the date?
The
Column,
30/12/1993.
Any column like that
Yes, lordship
in
will
this
find.
chart?
I have extracted at page number 21, I've given.
No, no, in this chart at
In
page
this chart, your
22,
lordship will find.
graduate scale, anything is
Yes,
there?
yes, after the name, your lordship will, in the right side, is a mark, I've given the underlining there, my lord. 30/12/1993. There's an underline.
No, there are columns 1 to
Yes.
1 to 17.
Yes.
It comes under which column? Number?
7. 7 in the next page, you will
Yes.
find page 23, the date,
Date of receipt of graduate.
30/12/1993. It's underlining there.
7. Yes, 30/12,
Yes,
93.
yes.
Private respondent is
Private
2009.
respondent, yes, Lordship.
So on this basis, you are claiming
Yes,
to be the in charge principal.
yes.
Why in charge? There's no permanent regular principal.
There is no regular principal.
Why? Since when?
Since the last retirement was done 23rd, 30th, 31st March 2023, earlier principal retired, my lord.
And what is the process now?
Now,
Or-
so for regular, the government has to give advertisement. It's a long process, my lord. At a district-wise selection list will be there and all will participate. It's a direct recruitment. Post of principal is filled up through direct recruitment.
Now, on what basis you are saying that this is the criteria for giving the?
It's a rule 12 of the Assam Education Manual.
Yeah.
Page number 35, I think, 35 or 32. Rule 12 of 2018 rule, my lord. Issue is not the seniority here actually, my lord. Actually, the issue is NOC. I have passed the master degree without taking NOC. They are alleging, my lord. Therefore, I was not given the charge of the principal. That is the issue. That I was debarred, my lord. But this issue has been already interfered by this honorable court. And many times this honorable court has directed that NOC is not a requirement if the person concerned has passed through ODL mode, my lord, from a recognized university. That is the already settled position. In spite of that, my lord, earlier occasion, they have what they have done. On the first round of litigation, honorable court has directed Mandamas, my lord, to give me the post of in charge at principal. Thereafter, they have passed an impugn order by stating that I may be prosecuted for departmental proceedings. And in spite of direction stay order of this court, my lord, they have started proceedings, my lord, against me. We have put to challenge all these things, and all these things have been set aside and quashed by this honorable court. Now they have passed another impugn order, my lord, whereby they have stated that yes, because I have crossed my 3 years of service length, therefore I would not be given the
3 years of remaining balance.
remaining balance period, my lord. Therefore, I would not be given. But the cause of action started in the year 2023 when, my lord, I was having the age, my lord. They
Show me
have-
the impugn order,
Yes, lord.
impugn order. But
Page 44, my lord.
44. They have not responded to this writ petition, it seems. Till now. It's a new case.
Yes. And this ground is not at all tenable for the post of in-charge principal. In the morning, I have given you, your lordship, an order that in item number 10, I have given you, lordship, a copy. That copy I am also giving now. The concerned incumbent is going to retire on 30th of this month, my lord. And she has been given the charge on 24/10/2025.
Just a minute. What is this rules of 2018?
Rule of 2018, my lord, which is specific. Rule 12.
Some secondary education for the school.
It's at page 32, my lord.
Of this book.
This book, this old 32. This book is, I think, combined volume. 32, I think.
Some secondary education for the school.
Assam Secondary Education Provincialized
Ah.
Schools, rule start.
Rule 12, 3-5.
Yes. Your lordship will find in rule 3, minimum qualification. The candidate must be MA, MSc, MCom with BT, BEd degree from any recognized university, having uniform good academic criteria in respect of Hindi teacher having degree qualification. The Hindi Parangat and Nishant shall be considered instead of BT.
No, you come to 5, subsection 5, sub rule 5.
Yes.
This is what they're saying.
Yes, this is what they're saying, but this is in respect of direct recruitment, my lord. This is not in respect of in charge. If the post is filled up through direct recruitment, your lordship will find recruitment to principal and procedure thereof.
Mr. Sharma, you don't interfere like that. You have the habit of doing that.
The post of the principal in provincial and
Yes.
higher secondary schools shall be filled up by direct recruitment from the candidates amongst the cadre of postgraduate teachers of senior secondary and higher secondary schools and graduate teachers of higher secondary schools as per procedure under sub-rule 5. The post of principal in provincialized senior secondary schools shall be filled up by direct recruitment from the candidates amongst the cadre of postgraduate teachers of senior secondary and higher secondary schools as per procedure under sub-rule 5. Explanation. The senior secondary and higher secondary schools shall include senior secondary and higher secondary schools in the state. The minimum qualification for appointment to the post of principal in higher secondary school and senior secondary school shall be as follows. The candidates must be MA, MSc, MCom with BT, BEd degree from any recognized university having uniform good.
Mr. Prokasta, why do you keep on reading like that? You already said that this is for direct recruitment.
Yes, I have.
So what's the point of reading all these things? Now, but tell me, what is the procedure for in charge?
In charge is generally, my lord, the senior most teacher, qualified senior most teacher of.
Any
the school.
separate provision for that?
No separate provision. There is no office memorandum, nothing like that. Only the practice is there. Practice is that the senior most teacher of the school having this graduate scale of pay.
Any authority you have?
It is their order, my lord, itself. They are
What order?
they have given in charge order. I have given the additional affidavit. I have
In
given
charge order to whom?
in charge order to some other school, my lord. They have given the principal in charge order.
Ah.
The person is going to retire on 30th of this month. And only before 1 month, they have given the charge.
On that basis.
This is the order.
Although he's not having that 3 years.
Yes.
Still, you said
Yes,
you
and
should be
through
given.
additional affidavit, I have given the example of two orders I have also added through additional affidavit. my
So we'll ask him to get instructions on that, on the basis of what you're saying. And
Yes, my
court-
learned friend can take it.
Court may not decide on that because
They are doing all these things to me only. They should be fair, at least to all the teachers uniformly. This honorable court, when directs mercy, it directs for all.
you want me to refer to that order?
Yes, Lordship.
Give it to me. Please write down, Mr. B. Prokasta, learned counsel for the petitioner submits that the petitioner has been deprived of being the in-charge principal of the what is the name of the school?
Satyabari Higher Secondary School, my lord, Borpeta.
Where do we get that?
This is synopsis I have given, my lord. First line, second line.
They are not a party here.
Lordship?
The school is not a party.
Yes, a school private respondent is a party of. Satyabari Higher Secondary School.
Of Sathebari High Secondary School in the district of Borpeta. For one reason or the other. To stop by filing this writ petition, he submits that the petitioner has challenged the order dated 21/6/2025, by which he has been deprived of being the in-charge principal in view of Rule 12 bracket 3 bracket small Roman 5 of the Assam Secondary Education open bracket provincialized schools close bracket rules 2018. Stop. The learned counsel submits that the said provision is basically for direct recruitment and not for the purpose of placing somebody as in charge principal. Stop. He submits that ordinarily it is the senior most teacher of the school who is given the in charge principal, and the petitioner being the senior most should be placed as the in charge principal. Next para, he further submits that the stand of the respondents through the impugned order dated 21/6/2025 cannot be accepted in view of the fact that in a case of similar nature, a person who hardly has 1 month of service left as teacher has been placed as the in-charge principal of the school concerned.
What am I quoted?
Instead of headmaster, you write headmistress. Stop. In this connection, the learned counsel has produced the order dated 24/10/2025 issued by the Director of Secondary Education in respect of Kalu Gaon High Secondary School, Sibsagar district. Stop. Mr. Talukdar, what is this WPC 925 of 2024?
Similar types of retribution, my lord. It was, she was initially deprived of my lord for not having the NOC. And this honorable court passed the order and thereafter contempt is filed, thereafter this compliance.
NOC means?
NOC, my lord, she was not having the NOC from the Department for Pursuing Higher Education, my lord. And
Okay.
without that, she has like this,
Then what was the direction?
NOC would not be requirement for cancelling the academic qualification, my lord.
Next para, Mr. U Sharma, Learned Counsel. Who will appear? You will appear.
Oh, no, but you locked it. But
You,
the
Sharma.
order, my lord, is not applicable because this is in respect of headmaster, my lord. Headmaster, there is no criteria as 50 is criteria.
And it is the matter of principle.
It is a matter of principle.
Principal, I have given the additional affidavit, page 55, your lordship will find, page 55 additional affidavit.
Where?
Of the additional affidavit I have given, my lord. Your lordship will verify from page 54.
Okay, and also, how do you say that he has got,
My lord, your lordship will find a date of retirement. Mr.
Where?
Nurul Habibur Rahman, your lordship will find at serial number 1, date of
where? Okay. serial number
31/12/23, and order was given on 30/12/22.
Stop, he also refers to order dated 30/12/2022, bracket annexure 8,
8B.
capital B of the additional affidavit filed by the petitioner, wherein one Mohammed Habibur Rahman Mazumdar, assistant teacher
Of
of
public
public higher secondary school, Hailakandi, has been allowed to hold the charge of principal with financial powers. Although he was to retire. What is the date?
31/12/23, my lord.
Where do you get the date?
Page 54, serial number 1, my lord, your lordship will find date of retirement at column number 8.
Okay, he was to retire on 31/12/2023. Next para, Mr. U Sharma, Learned Standing Counsel. Secondary education to obtain instructions by the next date. List on so and so.
Obliged, lordship.
Limits. I'm being the. You are there for the other side?
No, sure.
Okay.
Well, this petitioner is a subject teacher in English department of Beltola Senior Secondary School. Beltola Senior Secondary School. Earlier, this school and Beltola College was under one building, one setup. In 2010, the college was separated and they constructed their own building. Therefore, my lord, here your lordship will find that I have submitted some attendance register from 2010 onwards. Because during separation, some my lord, files were misplaced. Perhaps therefore this present principal could not give the attendance register of 2006 to 2010. But I have a next 2010 to 2018 because, my lord, she continued in Beltola Senior Secondary School from 2006 to till today. Now, the fact of the case is this, my lord, her name was duly forwarded to the respondent. My lord, first your lordship may kindly peruse the annexure 1 at page 17 is the appointment letter. Then, my lord, page 18 is her 30/01/2006 is her joining letter, my lord.
Okay, just a minute. Appointment letter
Yes,
As
page
lecturer.
17.
as lecturer.
Yes, as lecturer. At that time, both college and school part was same.
Okay.
Then, my lord, she joined on 31/2006 at page 18. Now, lordship may kindly turn to page
Later
9
it got separated,
in 2010.
10,
10
the school and college.
college.
You're in the
The-
college or in the,
No, I was in the school.
you're in the school,
Yes, yes. In the school, I continued from 2006.
but your appointment is as lecturer.
Lecturer, at that time, my lord, what happened? The governing body has given this name is lecturer, but the post is, my lord, that
You're teaching which,
Beltol, my lord,
you're teaching which class?
up to class 12.
Class 12.
Up to class 12. From
But you're called lecturer.
at that time, because, my lord, the name of the college, Beltola Mahavidyalaya Junior College. Therefore, as because this is up to Mahavidyalaya up to junior college is up to 12.
Up to 12.
Up to 12.
Hmm.
Therefore, they call me as a lecturer.
Earlier it was pre-university also.
Yes, yes, yes. Pre-university
Pre-
during 1983 onwards.
Yeah.
During that, yes, my lord. Now, lordship, I have accordingly joined on 31/2006. Now, next, your lordship may kindly turn to page 19. This is the main crux of the matter. On 18/8/2020, the name of the petitioner is at page serial number 4. Serial number 4.
Yes,
Uh,
Gitanjali.
yes, Gitanjali Devi. Her name was forwarded.
Hmm.
And for
Forwarded
this is
for?
provincialization.
For provincialization.
That status of scrutiny of particulars of senior secondary school for provincialization under the Provincialization Act of 2017 as amended up to 2017 as this is 18/8/2020. Then again, my lord,
There are so many names here. This is forwarded by whom?
by the college, by this school authority, my lord, that because during that period it is senior secondary school was, my lord, fully established. Because both of them, this college and school were, my lord, separated. Then, my lord, this is category of school, lord, so senior secondary school, this code so and so. At the top, yes,
Category of school,
yes,
senior secondary.
yes, yes, yes. Now, page lordship may kindly turn to page 21. After about 3 months, another list was forwarded by the same authority, and her name was also there in serial number 4.
Where is that page number?
Page, my lord, 21.
21.
Yes. The name of the school at the top, my lord, Beltola Senior Secondary School. Yes. Serial number 4, her name is there, Department English, PGT. She is MA as well as BEd. She is as a teacher, my lord. Her name was duly forwarded. Then, my lord, when this was, my lord, ultimately the school was provincialized, the posts were provincialized, her name, it should have been in serial number 4 at page, my lord, 23, but her name was somehow it is deleted. Without any explanation or nothing has been explained, my lord.
Page 23.
Yes. Now, lordship, therefore, the
Just a
petitioner,
Just a minute. Beltola. How many names appear here? Sewali Borua.
my lord,
1, 2, 3 appears. Number
Yes.
4 is not there. Okay.
yes, only number 4, her name is not there, my lord. In fact, I'll show your lordship may kindly the governing body forwarded the name of the petitioner is at page, my lord. Yes, at page 29, my lord. Two names were forwarded for two posts. Page 29. One, Mrs. Anjana Kolita, she was without my lord B.Ed degree, therefore tutor. And my name, second, Mrs. Gitanjali Devi, who has been serving in the college since 2000 till now. Here, one thing, my lord, I would like to point out regarding the principal and the governing body has forwarded at that time stating that teacher at Kendriya Vidyalaya Narangi from 2006 to 2012, but not continuously, should be appointed as a teacher either in English or alternative English. Thereafter, when, my lord, the name of the petitioner was not included in the serial number 4 and the other my lord, teachers as well as the staff were provincialized, then, my lord, petitioner submitted one letter to the director, which is at page 30.
Before that, this
Lordship.
not continuously, does it have any bearing?
My
Has
lord,
been
what
teaching.
happened? Because now the fact is this, my lord, they are claiming that I have not continuously working for 6 years. As per the law, my lord, 2017 Act, I'll have to continue at least for 66 years. But
So that
I'll-
is why page 29 itself says
Yes.
you are recommended, but it says that you have not done so continuously.
Continuously in Bentola Mahavidyalaya, in Kendriya Vidyalaya.
Kendra Vidyalaya Narangi.
Yes, not continuously, because the learned, my lord, the respondent number 2 has filed one affidavit
So
lastly.
does it mean that you're working at two places?
No. After completion of, my lord, what happened? Only 150 rupees given by the Kendriya Vidyalaya. Here I got only 2,000, my lord, in Beltola Senior Secondary School. After completion of this, my lord, at 2 p.m. I went to this Kendriya Vidyalaya. This is nothing, my lord, 150 per class.
No, that is why two places you're working
Yes.
on part-time basis.
Part-time basis. No, here it's full-time.
Where? Kendriya?
Yes.
Kendra Vidyalaya.
No. In, my lord, this Beltola Senior Secondary School. This
That's what. Beltola, you are full-time.
Full-time.
But at the same time, you are also working in Kendra Vidyalaya.
Yes.
Not continuously.
Not continuously.
And it is a part-time.
Yes, part-time. And, my lord, it's a very brief period. They have annexed one document.
So, do you mean to say that this has been misconstrued? It has been misconstrued that you have not been regular in the
Yes.
appointment
Yes.
in your original school, that is the
Beltola Senior Secondary School.
Beltola.
Lordship. Yes, my lord. Lordship is correct. Therefore, my lord, I have filed 2 affidavits annexing that from this senior secondary schools starts at 9 p.m. 9 morning, 9 a.m. my lord, till 2 p.m., 2:30 p.m. I always attend these classes. After finishing, my lord, I went to this Kendriya Vidyalaya. Now these petitioners, that during that way, the students' performance, lordship may kindly peruse at page 31. This is the performance during 2014-15, 15-16, and 16-17. The pass percentage in English department during during that period, because this is necessary to show that the her post is to be provincialized.
What is this written by the petitioner?
Yes, my lord. Because from the record, the performance of the students in English department, what was there, my lord? It clearly reflects that the performance of the students during that period was also very nice. Therefore, this post should be provincial. And otherwise, also, my lord, in all the colleges, schools, my lord, English department is major. And still, this petitioner, without, my lord, receiving any money, my lord, from the college, because after provincialization, she has been receiving nothing, my lord. Still, she is attending, my lord, classes. Only with the hope that this writ petition is pending since 2019. One day I will get the justice, my lord. Now, lordship may kindly first turn to page this first affidavit two affidavits filed earlier by this respondent, my lord. This is at page, my lord. This is the affidavit filed by the respondent, my lord.
Page
Here.
number.
Yes. Earlier two affidavits, lordship may kindly peruse. First
No,
affidavit-
just a minute. Before that, let us just go back to your writ petition again.
Yes, yes.
What is the basis on which you have made that claim? What is the basis?
Because the annexer, the representation speaks, my lord.
What is the ground basis?
Ground, my lord, without any reason, they have, my lord, not included my name in the provisional list, my lord.
Oh, that much.
Yes, yes,
okay.
only.
Now what?
And
What
now,
is
my
this
lord, the last affidavit, earlier two affidavits filed, lordship may kindly go, kindly may produce the earlier two affidavits filed by the authority, my lord. This response number 2, where, my lord, they have stated nothing regarding the at one affidavit filed
Where?
on 25/10/2024 by the response number 2, where paragraph 5 and 7,
Just a minute.
yes.
Who
Affidavit,
is respondent number 2?
this director, my lord,
Director of
director of secondary education.
secondary.
Yes. Same director has filed two affidavit, but one affidavit is sufficient because same facts. Paragraph 5 of this affidavit at page 41.
This is a general affidavit.
Yes, general affidavit.
They have not responded in paragraph wise manner.
Yes, yes, yes.
Ms. Musari.
Lordship, no.
Total 3 affidavits filed.
Lordship, we have filed two affidavits, one affidavit and two additional affidavits have been filed, your lordship.
By the respondent number 2.
By respondent number 2, your lordship, the affidavit that was filed on 25th of
October.
October, your lordship,
Of which year?
to
24.
25/10/2024
Arakan could be.
and 2011/2024. That's an additional affidavit. your
Where is
lordship.
that?
11 could put. 5% यहाँ पर.
First affidavit
First
is
affidavit. your
25/10/2024.
Yes, yes.
No
lordship.
reply.
That is first.
First, your
No reply. Yes. Wow.
and also an additional affidavit, your lordship, dated 2011/2024.
What was the necessity to file additional affidavit?
Lordship, in these two affidavits, your lordship, the reason why the petitioner was not, her service was not provincialized was not stated, your lordship. In fact, why another person named Anjana Kalita, why she was not provincialized, that was stated in those two affidavits, your lordship. So that is why, your lordship, this honorable court had asked me, your lordship, to obtain instructions as to why the petitioner was not provincialized.
Now you have answered it.
Yes, your lordship, and that.
In the affidavit filed on 24th September 2025.
Yes, your lordship.
Paragraph.
Paragraph 7, your lordship.
So ultimately that's that, 6 years.
Is
Yeah,
that because your
that is
lordship
this.
will peruse the provisions, your lordship,
Good, good.
which is at page 115, your lordship, of the education manual, your lordship.
What regarding 6 years?
Yes, your lordship, because
yes.
to be, for a person to be provincialized, your lordship, there are certain criteria, your lordship, that has to be fulfilled.
Rules or act?
Rules, act, your lordship,
Act.
So the act provides 6 years.
Yes,
There's no
yes.
dispute about it.
No dispute.
Only dispute is regarding whether he has or
Appeared or not.
Yes, your lordship. Whether-
she or he.
See, my
She-
lord,
she-
it's a lady.
She has 6 years or not.
Yes.
Yes, yes. 6
So
years.
that's why when I pointed out
Yes,
the
your
first instance, whether the working in that
Kendriya Vidyalaya.
Kendra Vidyalaya as part-time but not on regular basis
Yes,
Because.
has been construed as that she has not done 6 years.
continuously. That's why, my lord, I have
And
filed-
the recommendation was given by whom?
The DLC had recommended her name, your lordship, and when.
DLC.
Yes, DLC.
That
lordship.
DLC is recommended her showing that showing her name as Beltola Senior Secondary School,
Yes,
your
not Kendra Vidyalaya.
no,
Kendra Vidyalaya is a private school, your
Pri-
lordship.
private
It is a
school.
That's
private school.
why-
Yes, yes, your lordship.
Have you been mistaken in calculating the Kendriya Vidyalaya?
Because when it came to the state level, your lordship, when a scrutiny was made, we had seen that she had been working in this school in Kendra Vidyalaya, which is not permissible because she has to be in continuous service, your lordship. So that is what we thought that because
No,
she was working in.
Not
Kendra Vidyalaya.
permissible is a different thing.
Lordship,
Part-time is also a different thing.
lordship.
The school where actually she's working is senior secondary school.
Yes, your lordship.
And like Lord Council has said that since the classes are getting over by 2:30,
then only
she goes and
With the
attends that
permission.
thing. This is only as a part-time.
Lordship.
So by taking that part-time,
Hmm.
we have not included her in the list. Is that the reason?
My lord, one thing I point out,
No.
they have shown the list one RTI application reply at
Where?
page 55. The additional affidavit filed by the respondent number 2
Yes,
at page
where?
55.
Yes, which?
Here, the period, this is the only period. In 2007,
No,
January, February, March.
page 55, paragraph. Which paragraph?
No, no, my lord, Annexure 1. Annexure 1.
My affidavit. your
This is
lordship,
their
additional-
affidavit, my lord. The additional affidavit filed by the respondent number 2, my lord,
Page number.
page number 55.
55 is affidavit in opposition by respondent number 2.
Yes, yes. Their
So where in this affidavit do you want to show me?
Annexure 1, your lordship.
Annexure 1.
say
Pagination
that.
is not telling. Annexure 1.
This
Yes.
affidavit shows that I was working in Kendriya Vidyalaya because someone has filed this RTI before the Kendriya Vidyalaya, and this Kendriya Vidyalaya has given this reply information of Srimati Gitanjali Devi, contractual teacher, regarding with reference to your letter number so and so dated the attendance of Srimati Gitanjali Devi, who worked as contractual teacher in this Vidyalaya 2007 and 8, then 2008, 11 and 12 are furnished herewith. A sample copy of the attendance for the month of 2007 is enclosed herewith for your kind. In 2007, for the month of January, February, March, April, May, June, July, August. And in 2012, my lord, 2012, January, February, March, April, May, June, July, and August. Now, regarding in that, during that period, whether I attended the senior secondary school or not, I have filed one affidavit, my lord. Here, during that period, I have specifically given the attendance register as well as my attendance that after finishing my classes, I went there after
Where-
2:30 p.m., my lord.
Where is that?
Yes, at page, my lord, this is additional affidavit filed by this petitioner. It starts at page 50, my lord. And the attendance register starts at page 54. Page 54. If your lordship kindly compare the RTI, that letter regarding the month of January 2007, the first page itself is
Lordship, 2007 will.
7.
Will not be counting it from there because 6 years means from 2011 we'll have to count your.
Yes,
lordship.
yes.
From 2011.
No, otherwise also, my lord, 2007 to 2010, as I have already stated, the building was one, and ultimately the building was separated, and my lord, therefore the documents regarding the, my lord, attendance register up to 2010, they could not provide me. Therefore, I have annexed this 2010 onwards. In this affidavit regarding, my lord, 2011 July, I have attended. Next page, at page, my lord.
This is 11 onwards, I think.
Yes,
11
11 onwards. 11, 11, 11. All these dates where they shows that I was attending the classes in Kendriya Vidyalaya, whereas I have attended first in Beltala Mahavidyalaya, then I went there, Definitely, I did not, in my,
So your attendance in Beltola or your attendance in Kendra Vidya will count? Which one will count for provincialization?
first, my lord, this is Beltola Mahavidyalaya.
Hmm. So
Only,
what does the Beltola school
yes,
is headed by whom?
the
Principal.
principal. The principal and the governing body also party. My lord,
Principal
what
is a
happened?
party.
Yes, also party.
Who is appearing for principal?
Some governing body to party as well. Some. My lord, one thing,
Principal is there. Respondent number 5.
yes, yes.
Anyone appearing?
5 and 6, my lord. My lord, what happened? This respond number 5 principal, no permanent principal is there because this is one tutor. She cannot be a principal. Therefore, my lord, because there is no she is the senior most. This petitioner is the senior most. Otherwise, she would have been, my lord, the principal of this institution, my lord. Now, one junior teacher, she is a tutor. Now, she is, my lord, in charge, I think. She is, my lord, the principal of this.
So that is sufficient.
Yes.
Somebody has taken
Now,
in
the
charge.
copy of the attendance register was also forwarded. I have annexed that letter also to the inspector of schools. my
Anyone
lord.
appearing for that respondent number 6, 5 and 6?
5 and 6, my lord. 5 and 6.
And what about notice? Complete.
Yes, they received, my lord. And they forwarded to the, my lord, inspector of schools, my lord. The inspector of schools, my lord, has not filed any affidavit, but my lord,
Inspector of School Lordship, we will be appearing for them. I'll be appearing, Your Lordship, because
Right now, I'm concerned with 5 and 6.
5 and 6, those are private respondents.
now regarding the 6 years period, my lord, I have annexed the whole attendance register. Not even a single day she missed, my lord, classes.
Okay, requirement of 6 years is
Sufficient.
not disputed
No, yes,
as per the rules, as per the act.
yes,
Okay. Now, only question is that you have that 6 years or not.
yes. Now,
And
lordship may kindly turn
Please
to,
listen, what will be the clear picture will be given if the respondent number 5 and 6
Yes, yes.
can certify
yes,
that you have been working there regularly for the last 6 years.
yes, yes.
And if that affidavit comes, then matter ends. But
My lord-
now you are trying to show by giving some attendance register and
Yes.
all that. So court will not examine all that, you see,
yeah.
who has ticked, whether you have signed or not,
Definitely,
on which
definitely.
date. That arithmetic calculation is not necessary
Yes,
for the
yes, my
court
lord.
to do.
I admit.
Let the principal or whoever is in charge file an affidavit. Upon seeing the order sheets, I have not seen anywhere that notice is served to them.
Notice was served, my lord. I have, but they have not, my lord,
No, it's not served. Let me repeat that again. Only Lavazima court order is there. But pursuant to the order, nothing has been reflected in the court's order. Item is delivered, they say. The postal consignment was tracked. And it was found that item is delivered. But there is no order from the court saying that notice is accepted to be complete. That is not there. Now, what would be the best solution would be for this 5 and 6? If
Then,
they
my lord-
if they appear and say,
Mm.
we'll file an affidavit regarding his attendance. We vouch for his attendance. And perhaps court can take a decision and
Yes, yes, my lord. I may agree, my lord.
So in that case, then Kendra Vidyalaya School will also have to be made a party because he was working there.
No, I have not disputed.
Kendra Vidyalay's service rendered under Kendra Vidyalaya will not count for
Yes, yes,
provincialization.
Lordship, because,
Will it count?
Lordship, because to be provincialized, your Lordship, this particular teacher, she has to be there as a full-time worker, she has to be working in that school.
That is why she says,
Yes.
I am full-time in that school in Beltola.
Lordship, because.
But since I am off in the afternoon, I can serve as part-time in this Kendra Vidyalaya.
Because the attendance register that I have got from the Kendra Vidyalaya school, your Lordship, here it is shown that she attended her that Kendra Vidyalaya school from 7:10 to 1:45 p.m. your Lordship. Because here she has given a signature and the timing is also given, your Lordship. So from 7:10 to 1:40, your Lordship. So how can a teacher?
Be in two places.
Yes, your Lordship.
This is a new document, my lord.
Because why because it was because when this was filed, your Lordship, the annexure that I had annexed here. So what I had asked them was to give the attendance register in detail, your Lordship, because this was given not in details, your Lordship. So I had asked them. The director had asked from the principal, has requested the principal of the Kendra Vidyalaya school, and this document was given to us. Of course, it was after I had filed this affidavit, your Lordship, additional affidavit. So here what I have seen is that she was there from 7:15 to 1:45.
Okay, anyway, that is what you're holding in the paper. It's not an affidavit.
Lordship,
If you want, you can file it, but
Not sure.
we're not saying anything.
Lordship.
But you are there in that school. You can,
This attendance register.
can you not persuade them to appear before the court and file
Yes, yes.
something?
I can.
Today, as of today, we'll say that notice was delivered in view of the Lavazima court's order.
Yes, my lord.
And we'll adjourn it for some time.
Yes.
And you ask somebody from this 5 and 6
Let them file a
to
affidavit.
file an affidavit saying
Yes,
that
yes. It will be clear, my lord.
petitioner has been serving since so and so, and 6 years, definitely she's got that. Please write, parties are represented,
May I also file this as an
up to you. Parties are represented by the respective councils. Except for respondent number 5 and 6. Stop office, no, Lavazima court's order dated 9/4/2024 indicates that the consignment has been delivered to the addressee. Stop. Accordingly, notice is accepted. We complete on respondent number 5 and 6. Stop. Next para. Issue involved in this writ petition is with regard to non-provincialization of the service of the petitioner. Despite having worked in Beltola
Senior secondary school
Senior Secondary School
for more than 6 years.
for more than 6 years, which is the minimum requirement in order to be considered for provincialization of service. So according to the petitioner, her name was placed in serial number 4. In the list of teachers, indicating the status of indicating the status of the appointment. Stop. However, when what is this annexure, page 23, where your name went missing?
Oh, yes, my lord. This is the result of the provincialization.
However, when provincialization was done, the petitioner found that her name was excluded. Stop. Ground taken to oppose the writ petition is that the petitioner has not served continuously for 6 years, which otherwise is denied by the petitioner. Stop. The respondent number 5 and 6 are the principal and governing body of the school concerned. And an affidavit regarding the attendance and length of service of the petitioner. Filed by the said respondents would be necessary. To accept the contention of the petitioner. Stop. Since the respondents are not represented today, the matter stands adjourned for 2 weeks. Stop. Ms. T. Musari, learned standing counsel. Secondary or higher?
Secondary.
Secondary education submits that she may also be allowed to file file an additional affidavit to incorporate materials which will be relevant for consideration by this court. Prayer is allowed. List. After 2 weeks,
Yes,
you talk with your school.
Yes, yes.
Let them file something.
yes.
Hmm.
It will be better for me.
Yes.
Oblige me.
Alright, Your Lordship. For hearing item 15.
Please, my pleasure, Lord.
Yes.
So in here, petitioner was serving as a president of SMDC of a school, Lordship. I had appointed at
SMDC means?
School Management Development Committee. That is the honorary post, you know. Lordship, Annexure 1, page 16 is the appointment.
What is your grievance?
Lordship, I was removed from
You have been removed
removed
from
without
the membership of the SMDC,
Lordship, from the post of the president, Lordship.
post of president.
President.
And then now you are still as a member?
Lordship, no.
Are you a member? No.
No, Lordship.
You're not even a member.
No, Lordship.
And what is the provision for being appointed as nominated as SMDC?
Lordship.
Provision under what? Who's appearing for the respondents? You are for which respondent?
For 7, Lordship,
7. Who's respondent number 7?
the one who's holding the post of president, Lordship.
Hmm?
I'm holding the post of president.
The new president.
Yes.
New president, Lordship.
And
And for appointing of Codex Committee.
deputy commissioner. And who else?
So I
I am
am
appearing on behalf of D. Gogoi for respondent number 3 and 5, my lord.
Mission director.
Mission Director, RMSA.
What is the role of mission director here?
an order was issued by Dame Lordship.
Impugn order at page 47, Lordship.
Okay, this is a school, isn't it?
My lord.
The school, what kind of school is this?
High school, Lordship.
High school.
High school.
High school. Lordship.
This is run by the mission director. Rashtriya Madhyamik Shiksha Abhijan.
He was also in charge of inspector of school, Lordship, at that time. The kindly
Who,
stated-
petitioner?
No, no, Lordship, the issuing authority at page 47, Lordship, impugn order. Page 47,
47 is the impugn order.
Lordship.
Impugn inspector of schools.
My lord, they are challenging this order. My lord.
This order, page 47.
Yes, my lord, another 11, my lord. My lord, this is an order issued by additional deputy commissioner to Mohammed Zakir Hussain, my lord, the petitioner himself, my lord. He was the then president of school managing SMDC, my lord.
Additional DC is also the inspector of schools.
Sometimes he was supposed to be in church, my lord.
But he doesn't say in charge, he says the additional DC and inspector of schools.
Come,
Isn't that-
additional DC not looking for come DPC, my lord.
My
So
only,
first of all, I want to know what is the provision to become the member of the SMDC? What is the requirement? And whether you can be changed like that, and what is the term? Then we'll come to the facts.
my only pair is that without issuing any notice, any so cause lordship, I have removed from the post lordship.
Maybe, but at least we need to know the background, you see. Of the manner in which you are appointed as president. You have understood what I'm saying?
Lordship.
There'll be a provision somewhere saying that management committee or the SMDC is composed of so and so, so and so,
Lordship.
prominent citizens of the locality or whatever. And this is how they are formed, and the term is normally for this much time. And somebody will be appointed president, somebody will be the secretary, somebody will be the members, like that. So you are appointed on so and so date, but suddenly, without any notice, I was removed like that. That's how it should proceed. At least tell us under what provision you have been appointed.
Uh,
Do you get appointment orders or not? Or
yes,
not?
at page 16, lordship.
16,
16, lordship.
district program coordinator, RMSA. RMSA has a separate council.
Yes, my lord. D. Gogoi appears for this one.
You are presenting him.
On behalf of-
Okay. Government notification. Where is that government notification? Mr. Counsel, you want to prepare the matter?
Lordship, on next that lordship, I will.
All right. As paid for by the learned counsel for the petitioner, matter stands adjourned. For a week or 2 weeks?
Not 2 weeks, lordship.
2 weeks. The learned counsel for the petitioner shall make his submission as regards to the procedure under which the president and other members of the school managing committee,
School management and development.
school management and development committee are appointed. And for a period of and its term, TERM. Mr. Coleman.
Master.
16.
Please, your lordship. Respondent number 3 filed a affidavit. My lord, kindly see page number, my lord. 20.
Mr. Padgiri,
My lord,
you are starting from Z.
my lord.
You should start from A.
My lord, the matter pertains to non-payment of pension.
You think that I've read everything, is
My
it?
lord. And my lord, in pursuance of that,
Hmm? You have what?
my lord, affidavit filed by the respondent number 2, my lord, page 23.
Again, you're going for the affidavit. I don't know. You are very fond of the affidavit.
Paragraph number 4, my lord.
So just a minute, Mr. Padgiri. You are not ready for hearing.
My lord.
Are you ready for hearing?
My lord, already processed, my lord, therefore I am state that, my lord. The pension proposal already uploaded in the Kitagata portal.
Maybe, but
Here, what happened, my lord, this sent for mediation this case, my lord. And my lord, independent, my lord, the education department filed an affidavit. They sent proposal by portal, my lord, to accountant general, my lord. This is reflecting their affidavit. So I may be given some time to my lord to take instruction whether this proposal sent by the department, my lord. That much, my lord. So when I fix on 10th of this month, my lord, I'll take instruction.
Paragraph 24, my lord, it stated, my lord. Paragraph na page 24, my lord. Affidavit filed by the respondent number 3, my lord.
The pension proposal is already uploaded in the
Yes,
Cricket
yes,
portal.
ma'am.
Now the procedure is the department will upload it and thereafter the accountant
Yes,
general
ma'am.
will
Is the-
have to release the pension.
Yes, ma'am, it is. So I have to take instruction. Ma'am.
As regards the regular pension, it is stated that necessary document paper already been uploaded in Kitagata portal by EO Sri Bhumi for finalization of her pension. by the
paragraph,
accountant general.
which paragraph?
Paragraph 4, my lord.
Page number?
Page 24, my lord.
So we adjourn it then,
My lord.
Yes, ma'am, 10th of November.
10 November, okay.
My lord, his
Mm,
name may
please.
be shown in the cause list, my lord.
Please write down. By filing this writ petition, the petitioner prays for release of compassionate family pension and other death benefits on account of the death of her husband on 23/12/2018 while in service.
Is it easy, madam? It is easy, madam.
Stop reference to paragraph number 4 of the affidavit filed by the respondent number 3 has been made, wherein it has been stated that necessary documents / papers have already been uploaded in
Kitagata portal.
Krita Gyata portal by District Elementary Elementary Education
Officer.
Officer, Sri Bhumi, for finalization of her pension,
By
of the
the,
pension of the petitioner. Her means what?
by the AG, accountant general.
No, petitioner is what, lady or?
It has a, mala wife
She
of
is
the,
the
mala.
wife of the
Wife, madam, family pension, madam.
family.
For finalization of family pension entitled to the petitioner by the Accountant General Assam. Page 24, huh? You'll see the spelling and all that. Black mark, green black mark. Next para, Mr. S.K. Mehdi, learned CGC.
My lord, no, standing council is easy, madam. Accountant.
Oh, I'm sorry, Standing Council AG Assam submits that he may be given 10 days time to come up with up-to-date instructions.
And copy of the affidavit, my lord, actually, I'll take note.
I will provide.
I'll take note.
In view of above, list this matter when
On 10th of November, my lord.
10 November.
And my lord, actually, this matter should become in admission column, my lord.
My lord, wrongly.
So wrongly it is, my lord, there's no for, my lord.
10 November in the admission column.
Yes,
My
my
lord.
lord.
You give him a copy
Yes,
My
my
lord.
for your
And
benefit
my
only.
name has.
Shown in the
required
cause list.
to-
Name of Mr. S, name of
Standing council.
SC AG Assam be reflected in the cost list
Yes,
here.
committee member.
Name
You want your name to be reflected?
Yes, madam.
AG Assam will not do.
My lord, we are from 6, my
Of
lord.
AG of some-
6, my lord. So particularly.
Okay, SK Mehdi, AG Assam. SC AG Assam be reflected in the cost list.
Highly
of
appreciated.
like.
In the cost list.
Item 17.
Yes. Oh, it's one-sided.
One-sided today, man.
We have to balance. Now this side is heavy.
Well,
None appears for the petitioner when the matter is called, while Mr. A. Fukan,
for the elementary education.
elementary education, SC elementary education, who else?
6 and 7.
Mr.
KK Nandi for.
K. Nandi, learned counsel for respondent number 6 and 7. Ms. K. Fukan for respondent number 2,
But 9, your lordship.
and Miss
SD.
S. Day, learned counsel for respondent number 9 are present. For ends of justice, matter be listed after 2 weeks.
Deeply appreciated.